The brilliant lecturers and panelists we have with us today have and continue to contribute to the larger Me Too movement. They have so much to teach us, and we are honored to have them with us today. So we thank them and you for being here with us and being willing to engage in this important dialogue. I'd also be remiss if I didn't take a moment to thank my team on the Public Interest Law Review who made this symposium possible. Particularly, I'd like to thank Riley Henry, our symposium editor, who has worked tirelessly to make this event a success, and Rachel Legay, our managing editor, who has offered assistance throughout the organization of the symposium. Finally, I'd like to thank the faculty and staff at the University of Richmond School of Law, without whom this event surely wouldn't be possible. Now, without further ado, I'd like to invite Dean of the Law School, Dean Wendy Perdue, to say a few words and to introduce our keynote speaker.
Good morning, everyone, and welcome to the University of Richmond School of Law. It's great to have you all here. Of course, a special welcome to our alums who are here. We always get a good turnout for our symposium events, and we're delighted to have you back again. This is a fabulous program, and a special thanks goes to our students who put it together. You heard from Marianne Grover, and call out as well to Riley Henry and Rachel Legay. They are fabulous students who pay attention to what's going on in the world out there and focus on that as they thought about what to do a symposium on. And I have to say, it does feel like a topic, as they say, torn from the pages of the current newspaper. Certainly timely, and we appreciate the opportunity to explore the issues with an academic focus and in detail. I will say that some level revealing my age, I looked over at the sign that said "Lawyering in the Era of," and I saw "era," and what immediately jumped out at me was ERA. It used to be a thing. Maybe it will be again. On this topic, it's heartening to see the role that lawyers have played in this very important issue, particularly when it comes to sexual harassment in the workplace. Lawyers have been the first responders, and we are proud of the effort and impact that they've had. One of those important first responders is our keynote speaker, and I'm delighted to have the opportunity to introduce to you Ms. Sharyn Tejani. Ms. Tejani is director of Time's Up Legal Defense Fund. Immediately prior to starting in that role in April 2018, she serves as deputy chief at the Enforcement Litigation section of the Civil Rights Division of the Department of Justice. In that role, she supervised the investigation and litigation of cases on behalf of workers facing sexual harassment, pregnancy discrimination, and employment barriers that unjustly screened out women and people of color. Ms. Tejani has devoted her legal career to working on issues of civil rights and women's rights. Prior to joining the Department of Justice, Ms. Tejani was director of the Workplace Fairness Program at the National Partnership for Women and Families and the legal director of Feminist Majority Foundation. She's also worked at the Equal Employment Opportunity Commission as attorney advisor to the Commissioner Stuart Ishimaru. Ms. Tejani began her legal career as an honors attorney with the Civil Rights Division of the U.S. Department of Justice. She attended Yale University and Georgetown University Law Center. Please join me in welcoming our keynote speaker, Ms. Tejani.
Thank you very much, everyone, and good morning. My name is Sharyn Tejani, and I'm the director of the Time's Up Legal Defense Fund. The Time's Up Legal Defense Fund is housed and administered by the National Women's Law Center Fund. And we have 4 major projects. First, we match people seeking assistance after they've been sexually harassed at work with attorneys in our network. And the dean mentioned that one thing about the movement that's been very heartening is seeing how lawyers come forward. So we have over 700 lawyers who volunteered to join our network. And as network lawyers, what they agree to do is give a first free consultation to anyone coming through our network. And in that consultation, they walk the workers through what their legal choices are. So we get requests for help from workers from all over the country, and we give them the names of 3 attorneys that they can reach out to talk about what their legal choices are. That's one of the things we do. The second thing we do is we fund cases. We fund sex discrimination, sex harassment cases, and retaliation cases, mainly for low-wage workers. And in this situation, we've funded cases against Walmart, against McDonald's, against dollar stores, on behalf of farm workers. And the way this works is attorneys apply to us for funding. We review the funding applications, and if we can, we help them with their case. The third thing we do is we provide media assistance and storytelling assistance for people who are coming forward. Because sometimes when someone comes forward about sex harassment at work, it's simply too late. They can't bring a lawsuit, but what they can do is they can talk about it publicly. And people need help doing that, and doing that in a way that is safe. And so we help provide them with PR assistance. And then finally, in August, we announced the first of 18 outreach grants to groups that work on the ground with low-wage workers to help them learn about their rights and as it pertains to sex harassment in the workplace, and where they can go to complain, and what resources are available for them. So, since January of 2018, when we started, we've responded to over 3,500 requests for assistance with the names of attorneys and how people can get more help. The focus of all the work that we do at Time's Up Legal Defense Fund is low-wage workers. And that's because while sex harassment happens in all industries, to all types of workers, low-wage workers have more difficulty bringing it forward and being able to report it and being able to find assistance. So looking at who reaches out to us, about 1/3 of the people who send us requests for help are people of color, about 9% are LGBTQ individuals, and about 67% identify as low-wage workers. As this slide shows, we've received intakes from literally every industry you can think of. We've also received them from every state in the union. Now, as I said, our focus is low-wage workers, and the reason for that is because sex harassment at its base is about power, and low-wage workers have less power than other workers. They live paycheck to paycheck, and they don't have savings. They don't have easy access to transportation. They often live in communities where there's one big employer, and if you aren't able to get a job there, you're not able to get a job, period. For all these reasons, they're less likely to complain, and they're less likely to report sex harassment. In addition, certain industries are set up in a way that it makes it much more dangerous or difficult to complain. For example, if you are somebody who's a domestic worker, frequently your housing is tied to your job. And so if you complain about sex harassment and are fired or told that your job no longer exists for you, then you've also lost your housing. Similarly, for restaurant workers are paid below the minimum wage. They're paid what's called the tipped minimum wage, which is $3.33 an hour. The theory being that tips will make up for whatever they don't make to get them to minimum wage or beyond. But the tips come from customers, and so as you can imagine, if your customer is sexually harassing you, but you need the money, you are clearly not going to complain about the sexual harassment. So that's another reason why low-wage workers, sometimes the harassment is sort of built into the job situation that they're in. So one of the things we do at Time's Up Legal Defense Fund is we fund cases of sex harassment and retaliation. So the kinds of cases we fund include a case involving 2 postal workers who have been working at the same place for 15 years and been harassed by the same supervisor for 15 years. These women describe how they were terrified to go to work, terrified that he was going to follow them into a room, terrified of what he was going to do to them. But they couldn't speak up because they were afraid of losing their jobs. They found an attorney, and we're helping that attorney to bring that case. We're also funding a case of a low-wage worker who worked at a dollar store. She was being harassed by her supervisor, and then she got pregnant. And he was angry that she got pregnant because it meant that she was having sex with someone other than him. And so he cut her hours and finally terminated her. We're also bringing a case of a college student who was a musician who spoke out about the sexual harassment she encountered when she was trying to pursue her music career. And when she spoke out, that was in violation of the non-disclosure agreement she had signed. And so her employer is suing her. So we're funding that case as well. Now, because of the work that we do, because of the requests for assistance that we receive and the cases that we fund, we've had a chance to look at how the law is working, and the rest of my speech is going to be about changes we think should be happening in the law. Before I talk about the changes, I want to talk a little bit about the basics of Title VII so that we all have the same understanding. Title VII is the federal civil rights law that prohibits employment discrimination on the basis of race, sex, national origin, color, and religion. Title VII covers employers that have 15 or more employees, and it only covers employees. So that means in most states, if you're an independent contractor, you are not covered. And in most states, if you work for an employer that has less than 15 people, you are not covered. In order to bring a case, a Title VII case, the first thing a worker has to do is file a charge with the EEOC, or the Equal Employment Opportunity Commission. That charge has to be filed within a certain time frame. Depending on the state you live in, it's either 180 days or 300 days. Once you file with the EEOC conducts an investigation. And that investigation can take anywhere from a few months to a few years. Once the EEOC finishes its investigation, if it decides not to act on behalf of the employee, which is in the vast majority of cases, it sends the employee a letter, and the employee has 90 days after that to file a lawsuit, or the employee loses their right to bring a lawsuit under Title VII. So in Virginia, you have 300 days, because it's a state that allows for 300 days for filing, to bring your charge to the EEOC. But also in Virginia, like everywhere else in the country, you have 90 days after your right to sue notice to bring your case. Now, for sex harassment, one of the good things about the law as it stands right now is that that 300 days doesn't start until the last incidence of sex harassment. And so many times when you're talking about verbal or physical sex harassment, what you have is a pattern of comment after comment after comment, or grabbing or groping or assault, one after another after another. Now, if it had to be that you had to file after the very first one, more and more people would be out of time. But the way the law works, one incidence of sex harassment has to have occurred within that 300 days for the case to be considered timely. Now, even with that slightly generous piece of, you actually only need one incidence within that 300 days, you don't have to file after the very first incident, so many people who come to us are out of time. And we hear from many, many people asking for help, telling us, this happened to me 2 years ago, this happened to me 5 years ago, you were the first people we're ever telling. Now, why is that? Well, as the dean alluded to, as we saw in the last month, people who have been sexually harassed and sexually assaulted frequently do not come forward, and they do not come forward for very valid reasons. People rightfully fear that they won't be believed. They hope that it will stop if they comply, and they're afraid that they will be blamed. Now, in addition to what anyone would feel in this situation, low-wage workers face even higher barriers. For example, they have to know where to go. They have to be able to find the office or get on a computer to fill in the EEOC forms. They need a time to actually talk to the EEOC investigator. But when you have a job that doesn't have an office, where you have a 15-minute break, and you have no privacy, how exactly are you going to do that? How are you going to take time off to go to the EEOC office to get interviewed? All of these things make it so much more difficult for low-wage workers to access this system. And for any worker, of course, you're worried about what's going to happen when your employer finds out, and you're worried about what's going to happen if your family finds out. So these are all the reasons why telling someone you have to report within 180 days or 300 days, or you have to file a lawsuit within 90 days can be very difficult. But courts don't recognize this. A good example of this is a Virginia case from 2014 named Martin v. Polanski School Board, which refused to toll the filing deadlines. In that case, Tony Lathrop Martin was the director of special education at the school system. Starting in March 2009, she was sexually harassed by one of the school board members. He asked her for sex, he commented on her appearance, and he told her she would never become a superintendent unless she had sex with him. And indeed, she was turned down for the superintendent job in 2010 and again in 2012. She filed her EEOC charge in 2013. Now, the case doesn't tell us exactly when she filed it, but you know, it happened in 2012 and she filed in 2013, and the judge says, you're too late. At most, it would have been 365 days instead of 300 days. And the judge said that's too late. Now, the argument in this case was that one of the reasons she filed late is that she had post-traumatic stress disorder because she was a survivor of childhood sexual abuse. And obviously, this man harassing her brought that all up again. The court said no. The court cited Virginia law correctly to say that tolling could only happen in exceptional circumstances. And that would be that your mental incapacity must be shown to have prevented you from understanding or maintaining your affairs generally. The court then turned around and held the fact that this plaintiff was actually competent in holding down a job and wanting to be a superintendent against her argument for tolling the time. The court said that she clearly was capable, and she's saying that she's capable of being a superintendent of the school system. Well, then she clearly couldn't have been harmed that much, and so she should have been able to meet the filing deadline. If you're well suited to overseeing a whole school district, the court said, it cannot be that you're incapable of understanding or maintaining your affairs generally. And so that woman was out of luck and out of time. These are some other instances of why people don't report. Another thing we see from our work is the need to improve the remedies under Title VII. So for sex harassment cases, the majority of remedy you will get is compensatory damages or punitive damages. But under Title VII, the compensatory damages and punitive damages are capped. Now, these caps were set up in 1991, and they have not changed since then. And they are set up based on the size of the employer. Now, in some states, the state law is more generous, and you can get higher compensatory damages and higher punitive damages. In Virginia, however, you cannot. This is the highest you can possibly get. And Virginia's state civil rights law actually says, under state law, you cannot get compensatory damages, you cannot get punitive damages, and you cannot get reinstatement. So if you're in Virginia, the better thing to do, obviously, is to go under federal law. Now, this chart shows you just what happens if you increase the caps based on inflation. And as you can see, it's significantly higher. But that's not even where the question should be, because when you think about compensatory damages, the point of compensatory damages is to compensate the person for what happened to them. Now, when you're assaulted, if your employer has 50 employees or 500 employees, the effect on you is the same. But if you work for a smaller employer, you're going to be able to get less money than if you work for a larger employer. Same thing with punitive damages. The point is to stop employers from doing something. But if you're a smaller employer, the cost will be less. It also creates very strange incentives for large employers, because the $300,000 cap for some large employers simply doesn't mean very much. So in 2005, there was a case where a judge gave the maximum amount, $300,000, against Walmart in an Americans with Disabilities case. And the judge said, I'm giving you the maximum amount, $300,000, and figured out that in 2005, it took Walmart 37 seconds to earn the $300,000 it had to pay. So for some large employers, this is just simply the cost of doing business. And so these caps need to be raised for that reason as well. Another thing we see is that juries regularly give plaintiffs much more than the caps, but then the amount is reduced because of the caps. So for example, there's a Sixth Circuit case about a woman who was an electrical worker, the only woman working with this group of men, and her workspace was filled with explicit sexual magazines, explicit sexual talk, playing cards. She was called a bitch, she was called a dyke, she was made to work alone in places that were not safe. The jury awarded her $400,000 in compensatory damages and $7.5 million in punitive damages, all of which got reduced to $300,000 because that's the cap under Title VII. Now, this is important for low-wage workers because it's difficult to find attorneys to take their cases to begin with. But if all you can get is this small amount of damages, it's much less likely that attorneys are going to take these cases. And so it makes it much more difficult for low-wage workers to find representation. Another place that we see where workers have a tough time bringing their cases is because of the standard of what counts as sex harassment. So in order for something to be sex harassment, it has to be, there are different kinds of sex harassment, but for the most part, it has to do with whether or not the harassment is considered severe or pervasive enough. And what happens is courts keep, so this is not a standard that's in the statute, it's not a standard that Congress had anything to do with, this is a court-made statute. And what happens is courts keep ratcheting up what it means and what you need to have to make something severe or pervasive. So there was a great case from 2016 in the District of Maryland that sort of went through what that district and the Fourth Circuit has found to be severe or pervasive. And so, for example, a court found that 24 ongoing instances for a period of a year, including statements by the defendant that he wouldn't mind getting into the plaintiff's pants, giving the plaintiff condoms. This happens 24 times over a year, but that's not severe and that's not pervasive. Another case, the court granted the defendant's motion for summary judgment when the plaintiff said that she was sexually propositioned while discussing her salary and benefits with her supervisor. So she's asking for, what am I going to earn? What is my job going to be like? And the response is, well, it's going to be like this if you sleep with me. Okay, still not severe, still not pervasive. Another case where a supervisor closed the office door and asked her to take off all her clothes. Not severe, not pervasive. What was considered enough is 12 incidences in 4 months that included fondling, kissing, and propositioning, or something where the plaintiff said the sex harassment was an almost daily occurrence, including requests about oral sex, accused of being grabbed and groped. So what happens here is when you have a case that says almost daily, physical, and there's also physical harassment involved, that becomes a floor. And anybody who can't meet that floor, well, then it's not severe or pervasive. And through the years, what's happened is it's getting ratcheted higher and higher and higher. So things that may have been considered severe or pervasive at one point are no longer considered severe or pervasive, and people can't bring their claims. The next thing we see that we think needs to be changed is the work around non-disclosure agreements. So there are two kinds of non-disclosure agreements. One is when an employee signs one as they start their first day of work. So it's a condition of employment. If you want this job, you have to sign this agreement, and you agree not to disclose anything that happens to you on the job, including claims of sex harassment. The second is that the worker signs one after they settle a case. So this first kind of signing on when you start your job, one of the notorious examples that happened recently was a DC restaurateur, Mike Isabella, who made all of his employees sign a non-disclosure agreement when they started work, including the waitstaff. So the waitstaff is earning $3.33 an hour, and they have to sign a non-disclosure agreement that says if they talk about what happens to them at work, they owe $500,000 and the attorney's fees for the employer. So what happened was people were sexually harassed at work, and they actually did speak up. And a court took one look at this and said, no, we're not going to allow that to happen. You don't have to pay your employer $500,000. Now, both types of agreements, both the ones that work pre-employment or as a condition of employment and the ones that happen after you settle a case, usually have stiff penalties against the worker. And as a result, workers are very frightened and worried about speaking out. Beyond the danger to the individual employee, though, what these agreements do is they allow serial sexual harassers to keep sexually harassing because nobody knows what's going on. They also stop workers from coming together both to bring lawsuits but also simply to support each other because they're not allowed to talk about what happened to them at work. Now, some states have started to change the law around non-disclosure agreements. For example, in Washington state, it's no longer legal to have a non-disclosure agreement as part of your pre-employment or as a condition of your employment. Washington state statutes also now say that these types of non-disclosure agreements, both as a condition of employment and as part of a settlement, should not be enforced if your testimony is needed for a civil case. And so in this way, you can actually get at the person who's the serial sexual harasser, because the person can actually break this non-disclosure agreement if they need to be deposed in another case. In New York, a new statute limits the use of non-disclosure agreements even in settlement agreements. And in New York, the requirement is that the non-disclosure agreement be at the behest of the plaintiff. So if the plaintiff wants to have a non-disclosure agreement, which happens sometimes because plaintiffs don't want this information out either, then you can have it. But if the defendant wants it only, then you can't. The New York statute also says that the plaintiff has about 21 days to consider whether or not she wants to have a non-disclosure agreement, and even after she signs it, she gets 7 days to decide to revoke it. The Tennessee one is more of a general one that says that if you cannot have non-disclosure agreements about sex harassment as a condition of employment. Now, in Virginia, the law does not, there's no change to this law. So in Virginia, it's perfectly legal to have non-disclosure agreements both as a condition of employment and as part of a settlement in a case. And in fact, for most attorneys, it's a pretty normal part of a settlement of a case to have that kind of non-disclosure agreement. But it does lead to these dramatically difficult effects for other people coming forward and for the women themselves. So the next issue I wanted to talk about is retaliation. And retaliation is important to us at the Time's Up Legal Defense Fund because pretty much every single request for help we receive includes an allegation of retaliation. And that takes many forms. It takes the forms of your shifts being cut. It takes the forms of being told that day, don't come back to work, there's no work for you. It takes the forms of people being told that, this project no longer has space for you, we don't need you here, or just simply being fired. And in fact, we're funding a case where the woman was working at a construction company and she was being harassed by the father of the owner of the company who also worked there. And so regular harassment, lots of verbal harassment, some touching, and she finally gets up her courage and she goes to the EEOC and she complains. She tells her employer that she's done this, and 2 hours later, she was fired after working there for 10 years. So this is just part of what happens regularly when employees complain. And the EEOC sees the same thing. About half of the charges they get include allegations of retaliation. Now, retaliation obviously is harder on low-wage workers. They don't have any funds to carry them through. They probably don't have any savings. And so when you lose your job, you lose the thing that's keeping you in your house. You lose the thing that's keeping food on your table. And as I said before, for domestic workers, sometimes that means losing where you live entirely. And low-wage workers are much more easy to replace. And so it's much easier for an employer to get rid of them. So the way retaliation law works, the first thing is you have to have either participated in an investigation about Title VII or employment discrimination, or you have to have opposed something that is illegal under Title VII. So that's either participation or opposition. And the good piece of the law here is that whatever you participate in or whatever you oppose doesn't itself have to be illegal. And so it has to be that you had a good faith belief that what you were doing, that what you were opposing was actually illegal under Title VII. For a retaliation case, a plaintiff shows that they either opposed or participated, and that there was an adverse action. And again here, the law is better than one would expect. Under Title VII generally, in order to bring a case, you have to show that something happened to you that was so bad that it affected your pay, so something like losing a promotion or losing a job. Under retaliation standards, it has to be something that would chill somebody from coming forward. And there's good law here about how that is very employee-specific. And there's a great case from the Supreme Court where the justices talk about retaliation could be, for example, if you're a parent and you need to leave work at a certain time to pick up your child, and your employer knows this and changes your schedule on purpose after you've complained, that could be an instance of retaliation. So you have to show opposition or participation, you have to show something bad happened to you, and then you have to show a connection between those two things. Once an employee does that, then the employer has the burden of production to explain what happened. And that's simply an employer standing up and saying, no, I didn't do it because of that. I did it because of this. There's no proof that has to be there. It's simply the burden of production. So what I would recommend is the law get changed so that it's not the burden of production, but rather the burden of proof on the defendant. And I know employers will say that that's more than they should have to carry, and that's not fair. But given how prevalent retaliation is, it's important that employees get more protection. And so if the employer has to prove, I didn't retaliate against them because of this reason, rather than just coming up with the burden of production, that might stem some of the retaliation that we're seeing. So this is our website, and you can go learn more about the Time's Up Legal Defense Fund. And for the attorneys in the room, we would love to have you volunteer with us. It's a very simple form that you fill out, and then you join our network. We would send you the names of, we will send your name along with some other attorneys when someone comes through who has a claim in Virginia. We also offer webinars and more training about sex harassment and retaliation cases. So I think we have time for questions. Is that right? Great. Oh, you're fine.
First of all, I wanted to thank you for the work that you're doing. It's so important. I was hoping, as one of the few non-lawyers and law professors, if you could talk a little bit more about the work you do helping people come forward with their story, because there are so many people that even if law changes, that law won't change enough to provide them a claim. And so if you could talk a little more about what you're doing for those groups of individuals.
Absolutely. So what we do is we work with a PR firm called SKDK Knickerbocker, and SKDK has a network of other PR firms that are willing to help out. We give people assistance through those PR firms to learn how to talk about what happened to them, how to do it in a way that keeps them safe, because as you may know, talking about this stuff is sometimes as traumatic as going through it when you first have it happen to you. We also help them think about whether or not coming forward makes sense. So several times what we've seen is that one person talks to a reporter, and then the reporter gets some other names and starts reaching out to people. And we get these panicked calls from people saying, yes, this happened to me. Someone from the New York Times just called me. What do I do? And so we help them both with a PR person to help them talk about what are their options, how could they do this, and also legal help to think about, if I did come forward, what would be the ramifications?
So, hi, I'm Sarah. I'm a third-year law student here at the University of Richmond. And I wanted to ask you about corporate social responsibility when it comes to matters of sexual harassment in the workplace. And I'm just really interested in this topic from an employment law perspective, that we have the floor being Title VII, which I agree with also needs to be bolstered a bit. And then you have perhaps certain corporations that are setting good precedent by having internal policies, including a way to check and make sure that the sexual harassment policies are actually working or being addressed. But could you speak a bit to what's in the mucky middle there? I know you spoke, and thank you for talking about low-wage workers and workers who might not have these robust corporate policies to give them any kind of protection.
So there are definitely changes being made on the corporate level. I think when the dean started, she talked about how when you see ERA, you think of the ERA amendment when you're of a certain age. There have been, requirements for training and sexual harassment training for a very long time. And what this movement has shown us is they don't work very well right now. And part of that is how they're delivered. They're sort of check the box kinds of things. They're very rote or on a computer. You don't really have to interact with anyone. You don't have to think about it. It's not really about your specific workplace. And so for all those reasons, it doesn't work very well. So one of the things that we're seeing is some companies are trying to have better trainings. And those trainings involve trainings that are in person, trainings that are very specific to this kind of workspace, and those seem to have better results. We've seen some companies decide that they are no longer going to use non-disclosure agreements or enforce them. Similarly, we've seen some companies decide that they're no longer going to require forced arbitration. Both of those things, I think, are very, very helpful to workers. Sort of a the next step for some companies is using climate surveys. So these are anonymous surveys where people get to talk about how they feel about the workplace in a way that doesn't make them have to come forward individually. And so doing that and then improving your policies or doing a training and then doing another climate survey to see whether or not anything has changed. I've also seen some policies about how you deal with high-profile harassers, which is a big deal for a lot of the stuff that's been in the press, because this is the rainmaker kind of person, and now they're sexually harassing someone. What do you do? And making them be treated like any other employee, not allowing them to get away with it, of course, is important. But it also sends an important message to the rest of your workers that you're actually going to be believed and have it taken seriously. I've also seen a couple of policies where they're using it as sort of a two-strike rule. So if you sexually harass someone and it's sustained, or the employer thinks that it actually happened, okay, you get disciplined, you get told that you shouldn't do that again. If anything like that happens again, you're fired. And it doesn't matter how high of an earner you are or how important you are to the company. That's the rule that they're going to hold you to. And obviously, if it's very, very serious sexual assault kind of stuff, you jump to being fired right away. But this sort of like, there's this set of strikes, and if there's 2 strikes, and you're out.
Hi. So my question is the solution to the problems with the Title VII amendments, Title VII itself, or getting states to adopt more progressive programs?
Both. It's important that, some states really have led the way on this, either with more damages, more time, but it's not fair. It's not fair that if you live in California, your employment rights are more protected than if you live in Virginia. And so it's important that there be a floor set by the federal law, and right now the floor is far too low. So I would argue that actually both things should happen.
Good morning. Thank you so much for being here. I'm a lawyer here in Richmond, and to kind of piggyback off your question, if there was one law or 2 laws that you would want to see changed in the next year, for example, in the Virginia General Assembly, what would you pick? There might be people here that maybe could help with that.
That's a big question. For sex harassment specifically, I think this thing about timeframes and damages. I mean, it's the difference between what you can get in California and what you can get in Virginia is remarkable. But all of the things, unfortunately, that I outlined are all really important for things to change, and there's obviously more that have to do with getting more women into the workplace, getting women safe in the workplace that would help as well. Actually, going back to your corporate responsibility question, that's one thing I didn't mention. The other thing we think that really helps is having diversity throughout the corporation. And so it's important to think about who you're hiring, how you're hiring, and having more women involved, because that seems to lower the amount of sex harassment that other women face. Thank you very much.
Hello, my name is Riley Henry. I am a third-year law student here at the University of Richmond. I'm also the symposium editor for the Public Interest Law Journal. I have the privilege of introducing Professor Lesley Wexler. Professor Wexler is a professor of law at Illinois Law School, where she teaches torts, law of war, and international environmental law. Before coming to Illinois, Professor Wexler taught at the Florida State University College of Law, excuse me, and the University of Chicago Law School as a Bigelow Fellow and lecturer on law. Professor Wexler has broad research interests, including international humanitarian law, human rights law, and sex discrimination. Professor Wexler specializes in those legal areas that reflect the movement of anti-discrimination and humanitarian norms through domestic law, international law, social movements, and corporations. She has written on the legitimacy of targeting depleted uranium landmines, along with a series of articles on human rights impact statements. Her work has drawn on cases studies using De Beers, Walmart, and Chick-fil-A. Professor Wexler earned her BA with honors from the University of Michigan and her JD with honors from the University of Chicago Law School. Professor Wexler is also the co-author of an upcoming paper titled #MeToo, Time's Up, and Restorative Justice. So without further ado, Professor Wexler.
Thank you so much, Riley, for that kind introduction and for all of the help in putting this together, and to the University of Richmond Law School and to the Public Interest Law Review for putting on this very timely panel. I am a lawyer, but I've been a professor for almost as long as I've been a lawyer, so I tend to think of law questions sometimes as non-law questions, and to me, Me Too is a perfect example of something that is both a law and a non-law question. So my talk today is about Me Too and procedural due process and what I call colloquial due process. To lawyers, due process is a question of constitutional law. It's a question framed within the constraints of government action, what interests are at stake for a person facing state deprivation of those interests, and specific bodies of law governing actions as diverse as criminal proceedings, administrative hearings. But as we're entering the first anniversary of Me Too, the question of due process is becoming increasingly detached from its formal legal setting and often applied unreflexively and, to my mind, inappropriately to non-legal settings. Take, for example, this tweet from President Trump in response to a White House aide who resigned, not fired, resigned in the wake of a corroborated domestic abuse allegation. People's lives are being shattered and destroyed by a mere allegation. Some are true and some are false, some are old and some are new. There is no recovery for someone falsely accused. Life and career are gone. Is there no such thing any longer as due process? Given my concerns about this non-legal or colloquial due process, I want to use my talk to provide lawyers, citizens, commenters, the tools to intervene in the Me Too conversation and help craft and reinforce more appropriate fairness norms in non-legal settings. So in the next few minutes, I'll do the following. One, I'll try to explain the difference between formal due process and what I call colloquial due process. And sometimes people who are speaking about due process are simply confusing. They think that a legal rule applies in a non-legal setting, and sometimes they're not confused. They have a normative preference. They think the legal rule should apply in the non-legal setting, and so I want to sort of disentangle that. I'll also try to provide some contemporary examples of colloquial due process that demonstrate either a mismatch, so the demand for process simply doesn't match the interests at stake or the setting, or a demand for protection for accused perpetrators that simply isn't afforded to Me Too victims under similar conditions, and why, if we're serious about being fair, that fairness is fairness for all. And in the last part of the talk, and this is still, I'm still very much in the thought process, trying to sketch out what it means to have a colloquial due process that encompasses the concerns of Me Too complainants and claimants, as well as Me Too perpetrators. So it's a lot to do. We'll see how much we get through, and I'm excited to hear your questions. So we'll start with what is due process, formally speaking, legally speaking. The Constitution, under the Fifth Amendment, guarantees that no person shall be deprived life, liberty, or property without due process of law. And that's generally understood to apply to the government acting against citizens and not to private actors unless those private actors are acting under color of law. And that's known as procedural due process. The Fifth and 14th Amendment also the 14th extends the Fifth Amendment to the states and is thought by many, but not all, to guarantee substantive due process as well. And in certain narrow instances, it is attached to things like punishments of excessive fines. So what does formal due process mean in the Me Too setting? So in the criminal setting, it means that one gets notice of the charges, a right to a full investigation, a right to cross-examine witnesses, a right to a neutral, impartial decision maker, as well as ancillary protection, so a presumption of innocence, a high standard of proof beyond a reasonable doubt. It is the strongest set of protections that we afford because the potential deprivation, loss of liberty, is incredibly significant. We also have due process protection in administrative settings, but they are much lessened because the interests of the person are also lessened. This has been a very big discussion in the Title IX setting. So in Title IX, punishments do not include deprivation of liberty, but individuals have significant interests in their ability to continue their education. Sanctions for students found violating Title IX can include no contact orders, barring access to dorms, exclusion from university housing, exclusion from classes, exclusion from campus, suspension or expulsion. For faculty members, it can involve loss of tenure, loss of employment, suspension from work activities, a requirement of an open door policy, and notice to the students. And under the Obama administration, there was something called a Dear Colleague letter that strongly encouraged, and one might even say directed universities to change their approach to many of the processes involved in Title IX hearings. And it resulted in some universities not providing notice of charges, but only notice of an investigation. In some universities, accusers may be anonymous. In some universities, accused may not have legal representation, may not cross-examine witnesses. And this change, this Dear Colleague letter and the changes in university have been very controversial, have been widely criticized, and have brought together some unusual bedfellows. So people from as far ends of the spectrum as Betsy DeVos and the American Association of University Professors have both voiced concern, as well as Justice Ginsburg, that these Title IX changes might not be affording sufficient due process. The last setting is punishment. Proportionate punishment is actually governed by the 8th Amendment. It's not governed generally by the 5th or the 14th Amendment. But I've included it here for two reasons. One is because there are some instances in which fines can fall under the 5th or the 14th Amendment. And I think much of the public, when they are talking about concerns with due process and the punishment that alleged perpetrators are receiving, are really alluding to this 8th Amendment notion as well. So for example, when Gayle King, who is a television commentator, spoke, she said, "I think when a woman makes an accusation, the man instantly gets the death penalty. There has to be some sort of due process here." And I think what she's alluding to is some amalgamation of notions that underpin both the 5th and 14th Amendment as well as the 8th Amendment. But given that we have people on the television, people in the news, people in Congress talking about these due process protections, it's worth remembering all the settings in which these due process protections do not attach. First, private punishment. So a child, his parents are informed by a 15-year-old girl that they think their 17-year-old daughter attempted a sexual assault. Parents are not required to provide any process before grounding him, taking away his car keys, telling him to apologize, any sanction that they want to take that is sort of doesn't run afoul of any other law, they don't need due process for. Hiring. Casting directors declined to hire actresses Rose McGowan and Annabella Sciorra because they have heard a rumor through the grapevine that they are difficult to work with, not governed by due process. Now, it may be, in fact, that that was an act of retaliation, but it's not one with which the actresses can bring a due process claim. Private employers. If you are in an at-will state and you are a private employer with private employees, there are no due process protections that attach. You may have contractual protections, and often many people, and hopefully lots of people do, you do not have due process protections. Refusal to consort. Friends who refuse to socialize with a member of their social group accused of having engaged in an alleged sexual assault. refusal to purchase, a sports enthusiast who refuses to buy Nike apparel after its support of Colin Kaepernick, a movie buff who refuses to pay money to see movies with Mel Gibson. There is no due process that attaches to any of these situations. So now that we sort of sketched out the legal constraints of due process and where and when they apply, how should we be thinking about all these settings in which Me Too claimants are coming forward, but formal legal due process does not attach? So that leads us to ask, why is it people want or think that due process should attach? And I think at the core of due process is a concern about fairness, a concern that when someone is accused of doing wrong, that they have an opportunity and an opportunity that is fair to speak out, to defend their name. And under sort of criminal settings, we provide robust protections. We give you the right to an investigation, to cross-examine, to impartial decision makers. But what if there is no government involvement and no deprivation of liberty, but simply a social or reputational sanction? What are you owed and by whom, if anyone? Let me give you a concrete example. Justice Brett Kavanaugh at his confirmation hearing said, "We live in a country devoted to due process and the rule of law. That means taking allegations seriously. But if the mere allegation, a refuted allegation from 36 years ago, is enough to destroy a person's life and career, we will have abandoned the basic principles of fairness and due process that define our legal system and our country. I ask you to judge me by the standard that you would want applied to your father, your husband, your brother, or your son." And because Justice Kavanaugh is a lawyer, this was a very carefully crafted statement. Notice that he did not say, "I have the due process protections and am being denied those ones granted to me under the Constitution." What he said was, "We're a country that cares about fairness. Judge me in a way that you think is fair." The problem for us is that's the beginning of the question. That's not the end. Too many people reflexively say, well, then the answer is to take the rules we have in the criminal system and apply them in all other settings. And I don't think that's a particularly helpful match, and I want to identify some instances in which it really seems, to me at least, as a mismatch. So take one example, the personal narrative. So someone who has experienced a sexual assault or sexual harassment has a Facebook post, a tweet, a blog post, a personal conversation in which they tell their story. Too often, I think people assume that that must surely be a first step of a legal proceeding. If you've come forward to tell your story, really we should just see this as time zero, and what we're heading towards is a Title VII suit, a Title IX claim, criminal accusation. But for many Me Too claimants, it's not. For many Me Too claimants, what they want is to tell their story. So for instance, Chloe Dykstra wrote a Medium post discussing an anonymous ex-boyfriend and his alleged emotional abuse of her. She was not making a legal claim. She was not saying he should be prosecuted. She was not saying he should lose his job. She was saying, I need to speak my truth. I need to acknowledge that what happened to me was traumatic, and I want to provide solidarity to other people who want to come forward and know that they're not alone. What was she seeking? Empathy, to educate, to provide support. It's an odd setting in which to demand that due process should or would attach. Her post does not demand judgment of innocence or guilt by other parties, though others may choose to make such judgment themselves. Take the aggregated personal narrative. So some of you may know there is a list called the Shitty Media Men list, and it is designed as a warning device. So if you are in the media world and you're going to take a meeting with someone, know before you go into the room that other people have had unpleasant encounters with this person. There is a similar list going around in academia to identify institutions and what responses they've taken to instances of alleged harassment. The people participating in these lists, aggregating these lists, do not owe an alleged unnamed perpetrator due process. They're not decision makers. They're not depriving them of any particular interest. They're not obliged to provide process. That doesn't mean there should be no check on these activities, but those checks are not due process checks. So what check might exist? Defamation law, libel law, but due process simply isn't the right tool. So think of another setting, journalism. What is it fair for journalists to report? What does it mean when people complain that journalists aren't affording alleged Me Too perpetrators due process? Again, I think it's a mismatch. Journalism is not designed to provide justice. Journalism is designed to provide access to information. Now, that doesn't mean that there should be no standards governing what journalists can and should report, but due process is not the best fit to determine or to help us understand when journalists are behaving fairly in reporting allegations. There are already mechanisms in place. So the Society of Professional Journalists Code of Ethics, which is widely followed, has lots of provisions that I think accord with Americans' basic notions of fairness. Those standards govern fact-finding and fact reporting. They direct reporters to not misrepresent, not oversimplify, prohibit deliberate distortion of facts. They require the gathering, updating, and correcting of information, limitations on when anonymity can be promised and an explanation of why anonymity is granted, seeking subjects of a story to allow them to respond to accusations of misdoing, and to label advocacy and commentary. Probably the one that I think we've gotten the most confusion about and made the least progress on is the so-called court of public opinion. So when you as a private citizen read a story, hear a story, are trying to decide what to think about a claimant and a claimer, how should we be thinking about what it means to make a fair decision in those settings? So who are you friends with? Who do you hire? When do you intervene? Who do you believe? And in saying that, I want to emphasize that it's always important to recognize just because we're calling it a court of public opinion, it may not be that really what you're being asked to do is to make a judgment of truth and falsity. Sometimes what you're being asked to do is to offer empathy, offer sympathy, offer support, offer an ear to listen. And to tell those people what you're required to do is offer due process doesn't make a lot of sense. That said, I do think there are lots of intuitions that Americans brought to the crafting of formal legal due process that are intuitions and norms and values that we share that we should be bringing to these more social parts of the Me Too conversation. So I never thought I'd be giving an academic talk in which I quoted a real-world cast member, but here we are. So Jacinda Barrett, in discussing Chloe Dykstra and Chris Hardwick, had the following, and I think quite astute thing to say. The accuser's story bears no resemblance to the one I shared, but what is of supreme importance is that every woman and every man deserves a voice. Accuser and accused, everyone deserves to be heard. A rush to judgment denies the right to due process, and the Me Too movement deserves due process. So what might that look like? So I have a few initial thoughts, and I'm interested to hear what you think. So the first is to enter these dialogues with an open mind, to be willing to believe alleged victims. Now, that lacks the simplicity of the term that's been going around, believe all women. But I think it adds some important nuance. Believe all women, in my mind, is a shorthand for a more complex idea. The reason we need to believe all women is similar to the reason we need to express that Black Lives Matter. Black Lives Matter really means Black Lives Matter too. It's not an implicit devaluation of others, it's a demand of equity. And believe all women, while a little bit lacking in its nuance, I think is a similar demand for equality. It is not a demand all women, whatever they say, regardless of what is said after that, that's the beginning and the end of the story, but rather a willingness to believe women at all. Because the lesson of Title VII, of Title IX, of our ongoing epidemic of sexual assault against women and men is that often victims aren't believed. And so we need to reset our expectations for what counts as a credible, believable story. And part of the beauty of Me Too is creating awareness and understanding that it's not exceptional. It happens all the time to all kinds of women and men in all kinds of settings, and to be open to those stories. So just as in criminal settings, defendants get a presumption of innocence, given what we know about the tolls and costs of coming forward and our background prior assumptions about the kinds of people that came forward, we need to change, right? So Me Too creator Tarana Burke has said, when we say believe survivors, it's not believe them without investigation, believe them without interrogation. We have set a precedent in this country of not believing, of thinking that women in particular are lying when they come forward with these allegations. So the mantra, believe survivors, is about, can we start with the premise that people do not often lie about the pain and trauma of sexual violence? If we start with that premise, that we believe that it can be true, then you can have an investigation, you can have an interrogation. So that's point number one. Point number two is a rejection of numeracy. One of the problems law and society often faces in trying to change systemic, pervasive bad behavior is that you try and start with the low-hanging fruit. And there's some virtue to that. Everyone can look at Harvey Weinstein and say, that man is a moral monster. Nobody in this country with a conscience thinks that anyone should be allowed to do that to any individual. And people across political spectrum, across all belief systems, that's an easy claim, right? We can surely all agree about that. But the danger, the harm in starting with Harvey Weinstein is that that's an easy case. It's a case where there are dozens, if not hundreds of women coming forward with evidence. Bill Cosby, right? Remember the cover of New York Magazine with all of the women sitting in the chairs, all of whom accuse him of wrongdoing? So my second point is the rejection of numeracy. Be willing to believe one woman, be willing to believe one man. There doesn't have to be eyewitness testimony, though that is strong support. There doesn't have to be physical evidence, though there can be. The same reason that one woman is reluctant to come forward is a reason why other women or other men might be reluctant to come forward. And it's also the case that while many perpetrators are serial offenders, not all of them are. Sometimes people commit a single bad act or commit a series of bad acts against a single person. So we know this from child abuse, right? We have the same problem of people can see sort of serial pedophiles in the Catholic Church, but that tends them then to discount the single instance within a family. Well, if this had happened, surely it would have happened to others. A third point, what would colloquial due process for claimants mean? Respect claimants' autonomy regarding their own claims. Don't disclose someone else's claim for them unless you are required to do so by law. I have, as many people do, almost an infinite number of criticisms of the Kavanaugh confirmation process, and they are not all geared at one side. So, for example, whoever chose to disclose Dr. Ford's accusation against her wish to remain private violated Dr. Ford, and that's a serious concern. So for those of you who are not mandatory reporters, I strongly encourage you to have access and awareness of anonymous counseling services so that people who come forward, you can provide them with options of how and if they want to pursue their claim. A fourth point, try your best to be a neutral decision maker. This applies across settings, whether you are on a jury in a criminal proceeding or you are simply a reader of a newspaper story about an alleged Me Too claim. We need not approach these claims with an assumption that one side is always right, but we do what we do in regular non-Me Too settings, which is we look at different kinds of evidence. We do research to understand why certain kinds of evidence might be present or lacking. We apply higher standards when we have a sort of higher consequence to the judgment. Related, so point, I think, number 5, is to understand and learn and educate others about the science related to sexual assault and sexual harassment. There is a wealth of academic and scientific information about why not just women, but men are reluctant to come forward. So the stigma often that women face is doubled for men. It is doubled for people from minority communities who have an extra burden of not being believed. And so learning about that, learning about memory. So I received many emails from alums of my university after I spoke out about the confirmation hearings saying, well, aren't you troubled by these discrepancies or how memory degrades over time? And I had someone write me a very moving story about how in Vietnam, on Christmas Eve, he had come on unexpectedly another batch of soldiers. They had a break in fighting and they sang "Oh Holy Night," and that it's been a memory that he's held near and dear for over 30 years. He remembers who was there, he remembers the song, and he's like, lo and behold, my brother found these letters I had sent to him, and the letters revealed that wasn't the song we sang. The people I thought were there, it was different people, and yet I would have been sure this was my memory, that this was true. And I think that's a legitimate concern. We need to understand how memory works, and I tried to explain. I said, well, the memory for good experiences and the memory of trauma, science tells us, can be different. I also was concerned, I would have been happy to see a scientist come and testify at the Kavanaugh hearings about how memory degrades over time, but I would have liked to also see someone speak about how binge drinking or blackout drinking can affect one's memory, right? It's a willingness to accept information and science that informs both sides of the case rather than simply limitations or criticisms of Me Too claimants. The last point, which I think is number six, which is as much sort of focus has been put on this idea that losing one's job is a punishment, that losing one's reputation is a punishment, that losing one's job attached to a Me Too claim will form a death penalty under which a person will not be able to be employed. I want to emphasize, I think those are serious concerns. I think that people who are accused of Me Too wrongdoing have serious interests at stake. But I think sometimes when we frame it as punishment, as a worry about excessive punishment or about due process, we're leaving off one side of the equation. We're leaving off what has been the colloquial punishment for the woman who experienced trauma, for the man who speaks out and is then retaliated against. Now, there are legal protections, so Title VII provides protections against retaliation in the workplace, but it doesn't provide protection for other forms of retaliation. So, for example, the actresses that are not covered by Title VII, when Harvey Weinstein says, she's crazy, she's a bitch, don't hire her, they don't have any legal protection. And it's not only about legal protection. When someone does something to sort of harm a victim, to think of that as a punishment as well and as something that society should take seriously at redressing. So much of the Me Too conversation has been focused on what should happen to the people who are accused. And I think that's an important conversation, but much less has happened. What should we be doing as society for victims? How can we protect them? How can we reintegrate them into workplaces? And so I think I will end with a quote, again, an unlikely source, Alyssa Milano. So she has been one of the early actors and very active in the Me Too conversation, and in talking about sort of the post-confirmation landscape said the following: I think that right now we are defining what due process looks like in non-legal settings. Because we never really defined it before, because women haven't come forward, so we really do need to have due process. What does it mean to have a fair investigation in these processes so that we can move forward, so that we can change the cultural and societal systemic institutionalization of sexual abuse and sexual assault? And with that, I'm excited to hear your questions.
So I have a question, but I'll just shout it from down here. So in a law school setting, I feel like sometimes we're a little isolated from how this plays out in the real world. And I guess I want to know, how do we serve as advocates and follow the interests, support the interests of claimants, and Me Too claimants and people who come forward in kind of this isolated law school setting?
Sure. So one thing that I think it's easy to forget is that Me Too at its core is a bottom-up conversation. And even first-year law students who tend to get immersed in the law school experience, you have friends, you have family. These conversations aren't just happening in law schools and in courts. They're happening in families, and they're hard conversations, they're contested conversations, they're happening with our friends, they're happening with our coworkers, they're happening when you go to the store and the news comes on. And those are all opportunities for individuals to intervene and say, you just said this person didn't have due process, but did you know? Due process doesn't attach here. And if what you really meant was this person is being treated unfairly, tell me why you think that person is treated unfairly. And we can talk about, we can have a discussion about what fairness means. To too many, I think the law is the beginning and the ending of the fairness conversation. And law tells us what fairness means in a limited number of settings, but it's for us to define what it means in all of those other settings.
Any more questions? So as you can imagine, we have to respond to this due process thing frequently.
Yes.
Do you have other language that you would suggest? Because I do get this question a lot, well, what about due process? And what I'd love to give is sort of the long answer that you've given, but do you have a short set of words
Something
instead of
pithy.
due process?
What's the question, please?
So the question is, when trying to have these conversations and you need a quick answer. So someone says, this is a problem, due process, and you need a one sentence or a one phrase as opposed to a 30-minute talk. I'm working on it, but I think the shortest version that I can come up with is due process for all. Because that incorporates, I think vigorous advocates of Me Too are not opposed to fairness for those who are accused. They just want to make sure there is also fairness for the claimants coming forward, and we have to decide what that means. So I'll keep thinking, but the short term, I think, is due process for all.
Yesterday's New York Times in the food section was an interesting article about the chef and owner of Spotted Pig and 5 other restaurants, where her partner and financial supporter, and he raised all the money, has been outed for all the sexual harassment. And she said, I knew it, but I felt powerless to do anything because he had the power over me with the money for the business that she created. And with closely held businesses like that, what do you do if someone holds all the money and you're the owner and still responsible? And I thought it was a very interesting twist on victimization. She felt victimized, but helpless.
Yeah, it's a great question. So the question is, what do you do when you're in a situation where you are not the one being harassed or assaulted, but you are in a setting in which someone who has power over you in an employment setting is behaving in a way that you don't feel empowered to speak out against? And as someone in academia, I can say this is not a problem limited to restaurants, right? This is a pervasive problem across all sorts of workplaces and frankly all sorts of social settings. So for example, I'm always disheartened when I see criticism of spouses, right? So man is accused of sexual assault, and the criticism is, why didn't the wife come forward? Why isn't the wife speaking out now? I think that in other settings, we understand why family members or friends may choose not to speak. It isn't to say we wouldn't encourage, that we wouldn't welcome their intervention, but to have an expectation that people with less power are obliged to speak out against those with more power doesn't strike me as particularly fair either. So what does that mean? I mean, my hope is that as society changes, people will feel more empowered to come forward. So I can understand a restaurateur saying, I knew it was happening, but prior to Me Too, just as I think no one would believe the victims, I also thought no one would believe me either. I find that to be a credible claim. The question is, what do we do now? What risks are individuals willing to take on to themselves? And it's not for me to tell you how much risk someone should take, but it is to say I see astounding acts of bravery every day by everyday citizens who have everything to lose in coming forward and speaking their truth, not only as victims, but also as bystanders. So.
Any more questions? All right. Well, Professor Wexler, thank you so much.
Thank you.
Good morning, everyone. My name is Ken Anderson, and I'm a second-year staff member for the Public Interest Law Review. Today, I have the honor of introducing Ms. Megan Zwisohn. Ms. Zwisohn is a Deputy Commonwealth's Attorney in Gloucester County, Virginia. Ms. Zwisohn graduated magna cum laude with a Bachelor of Science degree in Criminal Justice from Old Dominion University, and she received her Juris Doctor from Albany Law School, having spent her third year studying with the T.C. Williams School of Law here at the University of Richmond. Ms. Zwisohn has been an instructor in Old Dominion's Criminal Justice Department and has been an adjunct at William & Mary Law School since 2013. Ms. Zwisohn began her career as a prosecutor in 1997 in the Virginia Beach Commonwealth's Attorney's Office. She then worked for the Norfolk Commonwealth's Attorney Office as a Deputy Commonwealth's Attorney until joining the Gloucester County Commonwealth's Attorney Office in 2012 as the Deputy. Ms. Zwisohn has also served as faculty for the Commonwealth's Attorney Service Council's Trial Advocacy course since 2004. She's also been called on to lecture and train prosecutors and law enforcement officers on a variety of topics. She's currently a co-chair on the Executive Advisory Council for Teens with a Purpose, an organization dedicated to supporting teens in need through arts and encouraging community leadership. She also serves on the board of REACH, which stands for Reading Enriches All Children, and has volunteered as a shelter reader. This morning, Ms. Zwisohn will speak with us about working with victims in the Me Too era. So without further ado, Ms. Megan Zwisohn.
Will it mess up your recording if I don't stand right in front of the mic? Yes, okay. Dang podiums. All right. I can do it. First of all, I appreciate, as a prosecutor, being invited to be a part of this type of symposium. We often get left out of these discussions. I don't think anybody realizes the amount of work that we do with trauma victims and that we have been doing for years, especially with sexual assault. Not so much harassment, that's going to be more Sharyn's end, but with sexual assault victims. So the title of this, obviously, is Interviewing Victims in the Me Too Era, but I will tell you, I could have given this lecture 20 years ago when I first started, the exact same lecture. The Me Too movement, as has already been discussed by both Sharyn and Lesley, is the sort of that bottom start. It is a conversation starter that we have needed to have. It does not mean that this stuff hasn't been around for generations. It just means that a lot of people who normally would not have been willing to talk about it do talk about it, and a lot of people who had no idea it was going on are now learning that it's going on. So I wanted to sort of preface it with this. Let me just make sure that I'm working this the right way. No, I am not. There we go. Okay. How many people here have been or know someone who has been a victim of some sort of sexual violence or sexual harassment? That's my point. And there is somebody from just about every generation except for young ones in this room, right? We all have some sort of story to tell. So that's the first thing that you sort of have to remember when you're working with trauma victims, is that they're not the only one, you're not the only one, but we are all individuals and we all have our own story. So one of the first things you need to do is be your own client. You need to figure out your own, I'm a swearer, so I'll try to say stuff. My law students love it when I swear in class, it's really cool. But in this group, I'll try to be nice. And I do have to say, I haven't been back in this building for 23 years, and it's kind of weird to be here, but you got to figure out your own stuff first, because what we do, even as victims, is we judge other victimization as if it's ours, or we didn't react that way, or we should have done something, or we project onto them. And so you got to clean yourself up. So I came to prosecution because of what happened to other people. My best friend growing up was in a family with domestic violence. She was sexually abused by a grandfather, but then her stepfather physically abused her grandmother. And we were in 5th grade, and I would stay up with her all night to talk to her while the abuse was happening so she wouldn't have to listen to it. And my own parents were sometimes asking, why are you always staying over there? Why don't you invite your friend over here? She wasn't allowed to go out, so I felt it was my job. So early on, I sort of garnered the personality of protector, right? And I had my own stuff going on. The discussion with Me Too, my mom called to ask, how are you doing with all this? And the Kavanaugh, how are you doing? Because she knew some things that had happened to me. I said, I'm fine, but thank you for checking in, right? Because we do all have something, or we know someone. In terms of the discussion, I can't tell you, and women, you may notice this more, men, you've been sort of taking it in if it hasn't been part of your world already. When a group of women get together and start just talking about it, and there's a male in the room, and an open-minded male, the reaction I often see is, I had no idea. And that's when they say, I didn't know this was such a regular event. And then they start to see the psychology of why women don't speak up often, because it became part of our lives. It's just part of being a woman, right? Going through middle school, getting your butt slapped was just part of my teenage years, right? You know, and so it wasn't something that we thought immediately needed to be dealt with. But because chances are that something has happened, or you care about something that's happened, you need to figure these things out before you start working with trauma victims. You need to address your own personal traumas, what questions have you asked yourself? Because your victims are going to have been asking themselves those same questions. You're going to want to know how you felt judged, because that's how they felt judged. And what you don't want to do is put that judgment on them. And oftentimes we're actually individually judging ourselves, and that kind of helps. You want to think about who helped you most through that traumatic event, right? Who helped you and how they helped you. Because again, that helps you kind of understand more. And what is this actually doing if you're someone who's not willing to go to counseling? This helps you sort of self-counsel. When you reach that point where you can have a rational conversation with yourself, this helps you self-counsel as to, all right, how did I process this? Am I really okay now? What is happening? And I have to tell you, I had caffeine for the first time in 2 months, so my heart's racing like crazy. All right. And who made you feel worse? Right? If you did disclose to somebody, who made you feel worse about it? How did they make you feel worse about it? Because oftentimes, people can be well-meaning, but they still make you feel worse. You know, that initial question that we ask, you know, of women half the time, well, you know, were you alone? How much had you had to drink? I don't think it's your fault, right? That's what we always say. You know, there's nothing wrong. You should be allowed to go out to have a drink, but how'd you been drinking? Like, how'd you plan to get home? Those types of things. And so who made you feel worse about it? And try to craft how you're going to handle your interaction with victims as that, not that way, whatever that person was. And this is something we all have to keep in mind, right? I'm going to take a drink real quick. You cannot help other people unless you face yourself. And I believe strongly in that. I've been doing this 22 years, and I watch young prosecutors, young attorneys who become, who more have they want to like charge because they have an agenda of something. And while that's great to some extent, that agenda, when it's a personal agenda, will kill your career because you make decisions that are based on your personal agenda, your personal decisions based on what justice is. Or in the civil world, what the actual best outcome would be, whether that's settlement or trial. All right, when you have an interest, this is what you run the risk of. I've seen these things happen too. Being judgmental, like I said, of the victim's reactions, forcing the outcome on your victim that you wanted. No one came forward when, no one believed me when I was assaulted or when I was sexually harassed, right? So I think you need to get out there because we need to get this guy because I didn't get justice, right? And we say that to a lot of people who are doing this. And we even do it, Sharyn, I'm sure you've heard it especially with corporate stuff, like, you got to think about the other people, right? And that is something we have to deal with on a regular basis, is that balance between forcing someone to handle the agenda of society versus what's best for them. And then you miss your own unhealthy reactions if you don't deal with it. And I'm going to talk about at the end of this what vicarious trauma is. I can do 4 hours to 4 days on that topic. So I'm trying to rush this all in a half hour. So it's going to be very sort of cursory. But what happens is if you are a trauma victim yourself, or if you have been exposed to it a couple different ways, when you get in a similar situation, you don't know that that's probably going to trigger you. And that trigger then turns it on. There's a reason why I had a circle on that first slide, because this is all very circular when you're working with trauma victims. So preparing for the interview. It's like preparing for any job. So some of this is not going to sound like, oh, I needed a professor to stand up here and tell me what to do. You need to be prepared, right? But you need to be prepared for a couple of reasons. Sometimes that victim is going to come in and tell you everything right away. And if any of it is something like so shocking and you didn't know about it because you didn't read the report or you didn't read the intake interview and you didn't read the memo from your partner, you don't want this on your face, right? You don't want to look like, oh shit, that happened to you? Sorry, it just comes out. Okay, we have a young man in our office right now who cannot talk about women's body parts, right? It is just the hardest thing, and I'm sorry, if you're going to deal with these things, you have to learn to say vagina, you have to learn to say penis, you have to learn to talk about all the different things that you can do with both those things, including the mouth, right? So you're interviewing a victim, and she's telling you about what happens, and your face is turning bright red because you're embarrassed. That's not going to work, right? So you've got to be prepared. You've got to read any reports or any information that you have possible. You also have to be ready for any possible emotion. And this goes back to the slide about you can't be judgmental. You can't decide this is how someone should react after being harassed on the job, for 15, 20 years, versus this is how somebody should be judged by being raped by their mother, father, brother, stranger, right? Because everybody reacts differently. Some people will come in for their first interview and they're going to be angry and they want blood. Some people are going to come in and they're going to be angry at you, especially if you go into the criminal realm, right? I have a little girl right now who was sexually abused by her uncle. She hates my guts. Totally get it. Whenever she sees me, she knows what it's about. She's 10 years old. We had a preliminary hearing. She was crying and awful. When the defense attorney's asking her questions, she did great because she hadn't met the defense attorney before, didn't know what was going to happen, was not considered the person that she had to think about all morning telling the awful thing that happened to her, right? You don't know how that's going to feel, and that's going to affect you as well. The most number one emotion you're going to get a lot of times, which kind of throws everybody off, is no emotion at all. Especially those people who have dealt with institutional harassment or long-term abuse, family abuse that's been going on long-term, domestic violence abuse that's been going on long-term. You're going to get a lot of no emotion. You're going to get a lot of quiet. You can't think because there's no emotion that they don't care, that they're really not interested in pursuing what it is you're meeting with them about. A lot of it is because that's how they protect themselves. Because if they start showing emotion, it is not going to stop. And why bother showing emotion? Because it's just going to happen again. And I don't trust you because he or she has promised me over and over again it's not going to happen again. So I'm just here. Tell me why I'm here. And they'll be that way a lot. My students at the law school always laugh when we start doing client interviews and client counseling, because I always say have tissues and water available. You have to make the room somewhat comfortable. You have to make sure that, there's nothing worse than when a victim is talking to you and they just start crying. We've all done it, where you cry so hard, the snot just comes dripping out, and then you're looking around like, tissues, get tissues. It's a little thing. It's kind of like when the military has their go bag. If you're going to deal with trauma victims, your go bag should have water and tissues in it. You might not need them, but chances are you will. If you're in a prosecutor's office, or if you're in, I don't know if the Legal Defense Fund has anybody like a victim advocate, there are people that sometimes reach out to the trauma victims before they even get to you. Consult with them. Take the time to find out, have they expressed any interest with, in what they want to talk about? Are they hesitant to come forward? Do they really know what they even want out of this, right? Sometimes, like was talked about, they just want to tell their story. They're not out for blood. They just want someone to believe them, right? They just want someone to believe them. So familiarize yourself with trauma-centered interviewing techniques. This is sort of a catchphrase now, trauma-centered interviewing techniques. And I can't teach you this. There's, again, hours and days and weeks courses on this. But what it is, it's a lot more like understanding that a lot of trauma victims can't tell you from point A to point B what happened. And if they get stuck, you can ask them things like, well, do you remember hearing anything? Do you remember any music? Do you remember smells? Right? Because the part of our brain that is functioning during trauma is not necessarily the part of the brain that is really taking in everything that's physically happening to them. It's that disassociation. So the brain goes to what else is around? What else is around? So what was the color of the room? Do you remember that? And keeping that in mind. The other part of trauma-centered interviewing techniques is, I think Sharyn, you mentioned over time memories change. Lesley mentioned it a little bit too. We make the mistake, especially in law enforcement, and I will tell anybody who goes into criminal defense or prosecution, we make the mistake of thinking closer to the time of the act, the memory's going to be better. It just happened, so she should remember, or he should remember exactly what happened. You got to give him at least 1 to 2 sleep cycles, because the memory gets better over time with trauma victims. The brain protects a trauma victim by making it all kind of go away, except for the severe trauma that usually happens to the body that they have to face. So you have to have some sleep cycles. You have to let them know it's okay if they didn't tell anything, because in the law, as lawyers, this is what we often do. Well, you said something a little different last time, so that's an inconsistent statement, which means you're not credible. Learn the difference between inconsistent and the addition of more details. As soon as an addition of more details come in, lawyers almost immediately go, that's inconsistent. You didn't say that the first time we met. It's not inconsistent. It's remembering more. It's adding to the story, right? It's maybe correcting a memory, because memory can be really weird when someone has been traumatized. If possible, and do this for yourself, don't schedule 2 victims in a row. I know you can't necessarily do that in a job where that's your whole job, right? Your whole job is dealing with victims. But if you can, at least give yourself a few-minute break in between, because that's part of the trauma that happens to attorneys when they deal with this, is you're taking on everybody's stuff. And you go from one victim to the next victim, you're going to walk home, and the first thing, you want to know why we all drink? It's like, I just need to get a glass of wine, right? I just dealt with and listened to the worst things ever. So try to give yourself a break in between if you're going to be doing a lot of victim interviewing. And schedule more time for these interviews than you would a normal interview. If you've got someone who's coming in to talk about a sexual harassment claim or a criminal claim, give yourself more time. You know, there are times where chances are, and we're not really talking about kids in this lecture, but you know, my kid interviews my first time might only be 10 minutes because I'm not going to force them to talk about anything. It's like, hey, how you doing? This is who I am, and we work it through. And then the next time we play Uno, and then the next time we, then eventually talk to the child. But a lot of times your interviews are going to be longer because you're going to be pausing for crying, if possible. If probable. You're going to be trying to get information out. It's going to be quiet for a long time. That's also part of the interviewing technique we need to remember, and lawyers are horrible at this, absolutely horrible. Silence is not bad, especially when dealing with a victim who has been traumatized, right? Silence is not bad. A lot of times people have to think about their responses. And as lawyers, especially those who go into trial, we don't like that. We're like, question, answer, question, answer. That's how it should work, question, answer. Time yourself sometimes, like how long when you're having a conversation with someone can you handle before you like re-ask the question? Did they hear me? They probably heard you. They're just formulating how they want to answer, or especially with trauma victims, getting the guts to answer. And also, they're making a lot of decisions. Do I trust you to listen to my answer? Do I trust you to do anything with my answer? And they're weighing the pros and cons. Thank you. I told you, I could talk for hours. And they're weighing the pros and cons about whether or not they should answer. So let the silence be there for a little while. Be yourself. I see this with law students a lot. As soon as you enter like the law school realm, you've got to be like a lawyer, right? Everything's different. You have lawyer voice. You start making lawyer jokes, which are the worst, law student jokes to each other. I did them too. All your spouses and friends around you were like, shut up, that's not funny. You have to be yourself because victims will see through that. They'll see through if you don't have that comfort level with who you are. And that goes to the trust. Make sure they're comfortable, but also make sure they know that you're the lawyer. You're not their friend. You can be friendly, but you're not their friend because they're there for you for a reason. They're not there to make friends. They're there for an outcome, whether it's for civil outcome or criminal outcome, and they need to trust that when they go into that courtroom, you're not thinking like their friend, you're thinking like their lawyer. And sometimes that means not being super friendly, right? But you still have to make them comfortable. Do not begin by asking what happened. Don't jump right into it, right? It might even be your second appointment with them before they'll even tell you. Just get to know them. How are you? What was your day like today? Little stupid stuff that they teach you in client counseling in law school. Did you find the place okay? Just kind of get them talking a little bit. Start by asking them how they're doing. And that's super important psychologically to the victim because often the people that are there to meet you, people haven't cared about how they're doing. Because if they cared about how they were doing, they wouldn't have harassed them. They wouldn't have assaulted them. They wouldn't have done these things. So the simple question of how are you doing today can start a relationship off really well. Explain your expectations. You have to do that too. You can't keep them guessing. You have to tell them, especially with Title VII and timelines. There might be times you don't have the luxury to meet with them 3 times before you make them tell you everything that happened to them bad, right? But you have to tell them, I'm always going to be honest with you. I need you to always be honest with me. You're not going to always like what I have to hear, but you can guarantee that it's going to be honest. Depending on time constraints, this is the part where if you can give them a sense of control. I'm not going to ask you to talk about this today if you're not ready. You can come back. We can reschedule another time. That finally gives them a sense of control in what is happening in this story, part of their life. And then when you do finally get them to talk, don't interrupt. Don't interrupt. I see this, young officers on the street, experienced investigators, lawyers. When I sit in on other lawyer interviews, the victim starts talking and they're like, oh, you said 9 o'clock, so how did you know it was 9? Shut up. Let them tell their story. Listen. If you're someone who has to take notes because your memory isn't bad or isn't great, take a few notes. But go back and ask the details afterwards. Let them tell their narrative. Because what happens is if you start interrupting, they forget something that they were going to tell you. You start going down a path that might not even not be relevant because you haven't heard the whole story yet. So just let them do that. Don't ever say, I know how you feel, because you don't. That's incredibly offensive. You don't know how I feel, right? Doesn't mean I don't empathize with you. It doesn't mean I don't think what happened to you was horrible, but I don't know how you felt. We all handle things differently and have different reactions. You can say things like, I'm sorry this happened to you. I understand why you feel that way. All right. Don't touch the victim beyond a handshake. I'm a hugger, right? By nature, I'm a hugger. I've never hugged a victim on the way in. I've had a lot of victim hugs after the trial or after a sentencing. But this is all about their mental ability, what happened mentally to them and physically. The last thing you're going to want to do is invade their physical space. Handshake. It's also professional. And that's part of the ask them about surrounding facts. That's part of that trauma-centered. Don't ask why questions, right? We need to know the why. I'm going to go a little over, I'm sorry. The why part of this, we need to know, right? Because in criminal, what do they tell us all the time? Motive is not required. Baloney, right? You got to explain the whys. So the way you handle it with your clients or with your victims, the best way I think I always handle it is, I've got to ask you some questions. I need you to know that I'm not asking these because I'm judging anything. I'm asking these because the defense counsel or the counsel on the other side is going to ask you these questions. So I need you to start thinking about these answers, and I need to know the answers. So it's not you questioning, why did you go here? Why did you do that? Because automatically that's victim blaming. But you do, as the professional, not as their friend, have to have those answers. Right? You have to have the why. Why did you think it was safe to go with this person? Why did you go back to work after your boss touched your ass? Right? What was that reasoning? Because that's cross-examination fodder for days. And if you don't know the answer, you don't know how to come back on redirect. You don't know how to say, they asked you why. Let's talk about that. How were you feeling at the time? Well, a friend of mine had gone forward, didn't go, got in trouble. She got fired. Okay. Because the defense on the other side's not going to want to know the why. They're just going to know, oh yeah, because they went back after this awful thing happened. So they can argue to the judge or the jury, can't have been that bad, right, if they went back. But if you don't know the answer, you can't come back on direct and say, can you explain? They didn't give you a chance to explain. Please explain that. Well, I had seen 2 of my coworkers fired for the same reason, so I needed the job and went back. Explain the steps. Don't leave anything sort of to question, because again, it's about control. They don't have control in the situation to what happened to them. You need to give them a sense of control through the process. And just knowing the next step can be that way, right? Knowing the next step can be a sense of control. I give the victim homework sometimes, right? Start a journal. Start talking, thinking about things, you want to talk about. If there's actual things I need to collect, any witnesses, that type of thing. Again, it's not about you being lazy, it's about giving the victim a sense of control. If they have it, if you feel your victim's out, and if there's no witnesses, if there's nothing, you don't start saying you must come up with witnesses, You have to feel them out a little bit, but you write it down for them, almost like your teacher, your assignment, and it gives them something to do. And especially make sure they have your contact information, and more than ever, your email. And the way I explain emails to especially my younger females, the generational gap kind of thing, is there are going to be times where it's 2 in the morning and you think of something you want to ask me or talk to me about. You're not going to pick up a phone and call because people don't do that anymore. I'm not giving you my personal number so you can text me. I'm not going to say that either, but email at 2 in the morning when it's in your mind, when it's your concern, because the most we do as people to ourselves is keep things in our brain. The moment we verbalize it, the moment we get it out, ask the question, it's amazing, almost physically your brain feels lighter. So tell them at 2 in the morning, at 4 in the morning, when you're up and you can't sleep because of all of this and you have a question, get it out, write it. First thing in the morning, I'll get to work and see it. All right, and here's where the circle comes in, and then I'm going to have to wrap it up. This is where your story begins again, after all of this. And this is what vicarious trauma is. Doing public service work is not just hard because the outcomes aren't grand. It's hard because it affects us. And I never want to scare anybody away from public service work or helping others. But you have to know going in that when you listen to other people's trauma for extended periods of time over and over again, you start to feel it and it affects you. And we are very quick to say, no, she was the one that went through this. It's not about me. I'm good. I'm fine. I'm one of those people who somehow I can compartmentalize what I hear at work and what I do. Also, baloney. Some people are better at it than others, but after years, it's not going to happen your first year of your career. It's not going to happen your second year of your career. Maybe your third, maybe your fourth. I'm in the year 22, right? You're going to have listened to the worst of the worst over and over again. And you're going to have wanted to cry with these victims. And you're going to have wanted to reach across the courtroom and beat the living crap out of the guy that just got found not guilty for, abusing his wife to the point where she was strangled and passed out and lost brain function. You're also going to have to deal with the fact that you're re-traumatizing these folks. It is your fault that they are now in front of strangers that they have never met and telling the most intimate thing that happened to them. That they have an attorney who's out for blood and asking them questions and accusing them of all different kinds of things. Like that little girl that I mentioned she hates me. I get it. That's what I represent her traumatization to her, right? And that's why we mentioned before, I think Lesley said you can't out someone else's trauma, but be aware of what is available. For instance, in Gloucester, and I think other jurisdictions are doing this now, if you are a sexual assault victim, you can report it to the police or report it and not have to you can report it, but you don't have to file the report. You don't have to agree to go forward. You can go get a forensic nurse exam. You can go get all of these things. So 2 years later, if you decide you're ready to proceed criminally, we at least have the forensic evidence, right? There are ways to help other people. But part of your job as a public servant, in many ways, is to re-traumatize, and that will eventually affect you, and you have to remember that, and you have to figure out ways to deal with that. And there's a million ways. Again, I've done hours-long lectures on this stuff. So now I'm done. Sorry. Any questions?
This is a question about the interviewing techniques.
Mm-hmm.
When you're do you find that your techniques or methods change when you're interviewing victims of either sex or with different sexes? If you're interviewing a male versus a female?
Not the general techniques, no. Not the general techniques, because everybody has a lot of those same issues. I think you do have to be aware of some of the differences, though. Little boys are going to talk differently than little girls. So you do have to know how the different genders talk and think about things. The overall is not going to change that much. I'll tell you, I change more between adults and children And I'm definitely different between what type of victim you are. Right? I'm going to talk to a robbery victim a little bit differently than I am a sexual assault victim. As both are bad, there's sort of different elements to each. And that's the hard part of the job. It's not a one-size-fits-all. And that's the part of you can't expect your victim to be one-size-fits-all when they come in to talk to you.
I wanted to thank you. I was a prosecutor and did exactly what you do. I did it for 4 years, and you're exactly right. We were re-traumatized. My husband is living proof. There were nights I couldn't even come home and speak until 10 o'clock, and then it would come out. But that's not the point. My suggestion is the following. I became a public defender, and twice had my juvenile rape victims as my clients with drug addiction and alcohol abuse. And they knew me so well. And I said to them, and I could talk to them about anything on an intimate level because I had been their prosecutor for their rape cases, successfully, I might add, for both of them. And I said to them, how did this happen that you are now with me and I'm your defense attorney for the crimes you've committed? And it broke my heart. And so I make a suggestion that all prosecutors should know, because I try to say this. My team was too intimate with the victims. And one of my people was a victim of abuse. So they were the hugger. They were the, I'm going to take care of you. And it was the wrong approach. I didn't know it. I was too young to know it as a prosecutor, that was not the right approach. They needed to be interviewed and selected to do their victim advocacy job or their prosecutor job because they could be able to keep that at a distance, just like you said. So that's level one. I think prosecutors should all be examined to make sure that they are not reliving their own abuse through their victims. And that's level one. But level two, both of these two young women now then became adult, said, you all abandoned me. Once the trial was over, I had no one, I had nothing. And I had nowhere you all went and left me. And I think that was the thing that I learned once I became a defense attorney, was that the role of the prosecutor and the victim witness team, or whoever is doing whatever with their people, they need to realize that they need to give them over to another level of help, counseling, and to help them move there even before they leave the prosecutor's office, or whatever office it is. Because the abandonment, is what led to the addiction later. And that was a terrible thing for me to learn about my team. And they still felt comfortable with me. But anyway, I give that in that there's two levels. Prosecutors' offices and people need to be very aware of who they're hiring so they don't re-damage the people in the process, and realize they need to give them help as they go out on their way. But thank you for what you do, because I couldn't do juvenile defense. I couldn't do it for 9 years after I had done it as prosecutor, because it was too traumatic.
That's one of the things, if you've got somebody like a victim advocate, what we do with our victims, even the adult ones, is always find out who their support person is going to be after. We talk about counseling after, like it's a new stage in their process, because I think that is exactly right. You can't abandon them. And especially with my teen victims, I always make sure they still have my contact information. And I tell them, I know the case is over, but you know we're here for you. Because especially you do get to know them, right? And like I said, I've never given one a hug until after it's over. And they're like, yay, win, or we lose. But a lot of them, and this is the part you got to understand with prosecution, the real prosecutors don't go in it for a win-loss count. So I've had a lot of these sexual assault cases that are not guilty because of all the reasons the Me Too movement is talking about. And they will still hug you because you believed them and you gave them their day in court, because everyone thinks due process, so I want my day in court, right? And that's what you gave them. That's what you give them civilly. That's what you can give them criminally. So I always tell them, I'm still here. Oops. I think this just turned off, or I turned it off, or the battery's out. I'll listen over here. You do have to kind of do that, and that's why I always tell any of my students, if you want to go to the prosecutor, be a lawyer, don't go to the public I'm almost done. I'm an only child. I can make everything about me. Don't go into those fields, because really, if you choose public service, you're not just lawyering. You are also your scared straight counselor, your mental health counselor, your resource for all community activities and resources. Any other questions? Oh, got one up front and one coming down.
Can you talk about how you deal with juries, given this whole thing about judging victims, and how do you select your jury given that? Because we've definitely heard anecdotal evidence of people being pushed off juries because they've gone through something themselves or not wanting to be on the jury because of that, and then you get a jury that is completely unsympathetic.
So juries are an enigma. Really crazy. You got to do it in voir dire, and you got to do it the best way you can in voir dire. And you really have to question them. And you can't guarantee that they're telling you the truth when they say they can keep an open mind. But you have to, like, forefront or push forward the issues that you have. Look, you're going to hear from my witness, from the victim. That's the evidence we have. Is there anyone here who, for whatever reason, something you saw on TV, something you read in a book about forensics, could not convict someone based on the victim alone, even if you believed him or her 100%? You have to start putting up front, because you will get people that say, no, I can't do it. All right, that's cause. I don't have to waste a peremptory strike on you. That's cause. Because they can't follow the law. In Virginia, one person's word is enough as long as you believe it. You know, so I will do that a lot. With rape cases, can we all agree that people react to being attacked or anything bad in their life differently? Anybody here have siblings? Do you all react exactly the same way? When mom and dad fought, or when something bad happened in your family? You know, sometimes those are those open-ended questions, but chances are you know enough about people to know that not every sibling in a house reacted the exact same way to something bad that happened. So you start having to plan, in my mind. You also have to educate your judges a lot. And that's the part of just kind of keep pushing those voir dire questions with juries. And then the other part, I think, with juries is when it comes down to argument, closing argument, and rebuttal argument. You have to be realistic. Yeah, you can't just say, look, she's credible, he's bad, this is what's got to happen. You have to admit, this is the Commonwealth's case. And the truth is, if you don't think that she or he is telling you the truth, then it's a not guilty. But here are all the reasons why. You know, here are all the reasons why you should believe. It's also the way I do reasonable doubt. Is there any reason to believe that this person did it? And not shy away from the weaknesses of your case, right? But I think voir dire, especially like sexual harassment, if you sort of front load it and go through it that way. Very quick, horrible war story. Rape case, ask the question, have the one victim, that's what we have. She knew her attacker, he jumped in through her window, raped her, jumped out, was a friend of her mother's. I asked the question, the entire jury panel raised their hand, couldn't do it, couldn't convict. I asked for the panel to be struck. Judge said, no, they just didn't understand your question. He leaves, he comes back, he essentially reads them a jury instruction. And if anybody's read jury instructions, you know, it's like trying to teach, you don't even know how to become a lawyer in 3 years. It takes you about 3 years of practice to become a lawyer, and suddenly they've got 3 minutes to read an instruction to know the law, right? So the judge comes out, reads this long instruction about the prosecutrix and, you know, all this stuff, and no one raises their hand. So he said, see, Madam Commonwealth, they just didn't understand your question. So we go on questioning the jury. We have to do individual jury selection. Woman comes back, answering the question on that, but she looks at me and she says, you know, but that one question you asked, I don't think I convict on that. I looked at the judge. Judge essentially said to me, and I'm not kidding, you know, don't get your panties in a bunch. Okay, Judge. Go through the whole trial, not guilty. We walk out, we're making this a long day. Walk out, 2 of the jurors came up to me and said, we'd like to talk with the victim. I said, oh no. You know, I kept it professional. It was like, oh no. And like, I literally had my hand up, like, no, you're not going over there, right? I will relay your, what is your message? And I will determine whether it's worthy of relaying to the victim. We wanted her to know that we all, 12 of us, believed her 100%. We just didn't think that would be enough to convict. Reasonable doubt. That's why I think jury selection is so important when trying to front load and understand the psychology of who the people on your jury. There was another question. Someone came down to the mic.
How do you handle talking to a victim when their story doesn't meet the elements?
That's the toughest time. That's the toughest thing. Where we have to remember what our job is to try to find the truth. And if we have all these elements that don't match up, as prosecutors, we also have to acknowledge that not everybody's telling us the truth, right? So I will say many times, I won't tell someone I think they're lying. I will put it that there's absolutely no way that we're going to get a conviction, and I'm not going to put you through that. If we're already charged, the charge gets dropped. I mean, it takes a long time to do that, to learn the difference between when a victim is just sort of still figuring out what happened, when it's the law enforcement officer that wrote the report wrong, right?
Right, I'm thinking more towards like there are certain traumas that are very, very real to people that don't necessarily meet the elements of a criminal offense.
Oh.
I'm an asylum lawyer. It doesn't matter how much you were raped or tortured unless you were raped or tortured for specific reasons.
Right.
So when I interview clients, I have to explain to them that this very awful thing happened to you, but it still doesn't meet the element of asylum because they don't understand that just because something is terrible, they think, well, why my story wasn't terrible enough for you?
Right.
So
that is hard because, but I think you almost explained how you do it in your question. Is you can't sort of namby around it. You got to rip the Band-Aid off in many ways and go through that. You can't say I know how you feel. I understand how you feel. I understand why you feel the way you feel. Get that. The problem is my job is I have a very limited scope of what I can do. And the law does not allow me to do that. If I could, I would. But it's not something I'm allowed to do. If we can, we try to find other resources. We don't just shove them out. Most people who've ever worked for me know if they say it's not my job, that's like 10 demerits right away. Right? So we try to find maybe another person or agency that might be able to help. You know, because of who I am, an upstate New Yorker, I'll often say, you know, I wish there was a law that said I could prosecute assholes. But I can't, right? You can be as big an asshole as you want, but if you're an asshole under the law, you can keep being an asshole. So that's the way I sort of do that. I'll probably get rid of that for language in here, but...
Do we have any more questions?
I don't know.
Thank you so much. We will now take a short break until 11:20. We have snacks, coffee, tea, whatever you'd like in the atrium. Run to the restroom. We'll reconvene at 11.
Great. My name is Asia Reed, and I am a 2L staff member on the Public Interest Law Review. I have the honor of welcoming Professor Jennifer Robbennolt. Professor Robbennolt is a professor of law and psychology at the University of Illinois, focusing on the areas of psychology, law, torts, and dispute resolution. Her research integrates psychology into the study of law and legal institutions, focusing primarily on legal decision-making and the use of empirical research methodology in law. Professor Robbennolt is co-author of several books, including The Psychology of Tort Law, Psychology for Lawyers, Understanding the Human Factors in Negotiation, Litigation, and Decision-Making, a textbook on empirical methods in law, and the casebook Dispute Resolution in Lawyers. She has served as a secretary of the American Psychology Law Society, and as a chair of the AALS section on law and the social sciences, and is on the editorial boards of Psychology, Public Policy and Law, Law and Human Behavior, and Law and Social Inquiry. A graduate with highest honors at the University of Nebraska College of Law, she also earned master's and doctoral degrees in social psychology from the University of Nebraska. Before joining the faculty at the University of Illinois, Professor Robbennolt was Associate Dean for Faculty Research and Development, Associate Professor, and Senior Fellow in the Center for the Study of Dispute Resolution at the University of Missouri-Columbia School of Law. Today, Professor Robbennolt will be speaking with us about the range of remedies and responses in the Me Too movement. So without any further delay, Professor Robbennolt.
Thank you. I want to thank you for having me. Thank you all the Public Interest Law Review students for inviting me. And what I want to talk about today is the range of concerns that survivors of sexual misconduct may have and that their attorneys ought to have in mind as they represent them or represent the perpetrators of sexual misconduct. And I want to do that in part taking seriously the role of survivors and the notion that survivors have the right to control their cases and deserve to be accorded the agency to decide what their particular remedial goals are, right? So some survivors may have different goals than other survivors, and we want to think about the range of what those possibilities might be. In doing so, my background is in law and psychology, and what I want to do is draw on the social science research about how people respond when they have been injured. So I'll draw in part on the social science that looks at how tort claimants respond to their injuries and what motivates them to claim, but also the social science that looks at how people respond to sexual violence, what their motives for making claims might be, and what they say about what justice means to them. Okay? So one thing that many victims of sexual violence and of other kinds of injuries value is the chance to tell their stories. And we've heard a lot about that already this morning. They would like to be able to describe what happened to them and how it has affected them. Okay? They value having an opportunity to speak out, to voice their experience. That's going to manifest itself differently for different kinds of survivors. And in some ways, this is one of the hearts of the Me Too movement, right? Me Too provided many survivors with the space to tell their stories, with an opportunity to tell their stories, with the support from other people that allowed them to tell their stories. Some survivors may want to voice their experience on social media, others may not. Right? Some survivors may want to tell you, their lawyer, their story, right? And for some of them, for those of them that are not going to be able to have legal claims for the kinds of reasons we heard, that may be a very important thing for them, is to have some representative of the justice system listening to their story. Right? Some survivors may welcome the opportunity to tell their story directly to their perpetrator, and some survivors may emphatically not want that. So however it might manifest, simply being able to tell their story can be very empowering for survivors, and it's one of the things that many survivors want. Those who are injured by other people, including those injured by sexual harassment and other forms of sexual violence, also often desire some form of acknowledgement. Okay? Acknowledgement of their experience, acknowledgement sometimes of the specifics of the behavior, the specifics of what happened to them, acknowledgement about how that affected them. And that acknowledgement for victims can serve a whole host of different kinds of purposes, a whole host of different kinds of goals. It can confirm their experience. It can convey to them a message that they weren't overreacting, right? Or that it wasn't their fault, right? Because a lot of victims worry that they did something or that other people are blaming them, and to sort of acknowledge what happens to them helps them sort of understand that it was not sort of their oversensitivity or their fault that something happened. It can also signal community support for the victim, which a lot of victims find useful. psychological research on apologies, and there's a whole literature of research and studies looking at apologies, who offers them, how they're offered, and their effects on injured parties, has found that apologies can be more effective when an offender has taken the time to hear the experience of the injured party. Okay? And then to express an understanding, right? Even if not an agreement with, simply an understanding of their experience of what was done and how it has affected the victim. Right? So the same words in the apology, the same kind of thing that is said, can be understood differently if it has sort of followed a period of reflection, followed a message of understanding of the experience. Okay? Now, consider, I'm going to give you some examples throughout of sort of responses or apologies that have been given in some high-profile cases to sort of exemplify and counter-exemplify some of the things I'm talking about. So, as a counterexample to the kind of acknowledgement a victim might want, consider the response from snowboarder Shaun White when there were allegations of his own sexual misconduct. This response did not acknowledge the harm, it did not acknowledge the victim's experience, it did not acknowledge the victim at all. Right? And so not surprisingly, therefore, White was promptly criticized for further insulting the victim of the harassment. Offender responses, even when they are ostensibly apologetic, do not always provide the sort of acknowledgement typically sought by survivors. So, for example, apologies that are conditional, right? So the person says, if I did anything, right? Or responses that are vague or general, so they may refer only to behavior, right, or actions. Those kinds of apologies do not articulate an understanding, do not acknowledge the harmful behavior or demonstrate an understanding of the wrongfulness of the behavior or the effects of the behavior. Okay. Responses that cast doubt on the consequences of the behavior, so responses that say, if anyone was offended, right, can appear to lay the blame at the feet of the target of the harassment for misinterpreting or being overly sensitive. Okay. In contrast, consider an interaction between Megan Gantz and her former boss, Dan Harmon. And this interaction took place on Twitter and on podcasts, right? And on Harmon's podcast, he offered a lengthy apology that included fairly specific acknowledgement of the variety of ways in which he had created a toxic environment for Gantz, including the initial behavior that was problematic, but also the retaliatory behavior that had happened, and he acknowledged the ways that it had affected Gantz. Okay. She describes him as having given a full account of what happens. She also describes the relief that she felt at hearing him say that these things actually happened. So that it wasn't something that she had dreamed, it wasn't something that she wasn't crazy for having understood these things in these ways, right? And sort of, we'll talk later about sort of accepting apologies and so on, but she felt like it was appropriate to accept that apology, right? And in many ways, especially when we're thinking about public apologies, this tends to be the exception rather than the rule. You more often get very carefully crafted conditional and vague statements. Okay. Another way in which a response may fail to provide the kind of acknowledgement that survivors might be seeking is when the response is made sort of in general or to the wrong person, right? So consider as one example Charlie Rose's apology, which was to these women, right? Didn't name any particular women, even though there were particular women who had made particular claims. In contrast, for all its other faults, Louis C.K.'s apology, right, effectively acknowledged specific women who he had wronged and respected the agency of another woman who was not prepared to be named. Right? And so we could talk about the other faults in his apology, but in that respect, right, he got that acknowledgement correct. So these kinds of conditional or blame-shifting or vague apologies tend not to provide the kind of acknowledgement that many victims seek, nor do they provide any evidence of understanding of the wrongfulness of the behavior or of its effects. These sorts of failures are not only dissatisfying to many survivors, but in themselves can also sometimes constitute an additional offense. Right? They additionally provide examples of behavior that is wrongful. Okay? Simple acknowledgement is something that many survivors would welcome. Right? But survivors may also desire that offenders do more than simply acknowledge their experience. Right? They hope that their offenders will accept responsibility for their behavior and for the harm that their behavior has caused. So responsibility taking can be very difficult. This is the cover of a book that I like. The title is Mistakes Were Made, but Not by Me, right? So you've got the passive voice and also the blame shifting, right? And it's a book by a couple of social psychologists who sort of work through the social science about why it's really hard for any of us to take responsibility for our own wrongful behavior, right? There are many psychological reasons and many legal reasons why offenders may not be able to recognize that they have acted inappropriately or to accept responsibility for their behavior. Denial, embarrassment, difficulty in accepting that you've done something wrong that's inconsistent with our self-image as good people, concern for reputation, the belief that a denial will be a more effective response than accepting responsibility, right? One's own vulnerability, right? The fear that to admit responsibility is to cede control of the situation, right? And in many of these cases, potential legal consequences loom large, right? So concern for liability, whether that's civil liability or criminal responsibility, is often but not always in the background of these kinds of cases. So there's all sorts of reasons why it can be difficult to take responsibility. On the other hand, there's lots of social science that suggests that responsibility taking can be really, really powerful, right? So acceptance of responsibility for having caused harm is the central feature of an apology, right? It's the key element of an apology that distinguishes an apology from other responses that one might make to wrongdoing, right? It distinguishes an apology from denial. It distinguishes an apology from excuse making. It distinguishes apology from justification. Right? And a lot of empirical research, including my own research on apologies and tort victims, right, has found that accepting responsibility for having caused harm tends to contribute significantly to positive reactions to apologies. People tend to think that behavior was less intentional when someone apologizes for it, right? They're less likely to blame the person for the behavior if they apologize for it. My own research is on settlement negotiation. People are more willing to have settlement talks or settle cases when someone has apologized to them. Okay? Now, that's not to say that listening, acknowledging, expressing sympathy, things that sort of don't take responsibility but are also appropriate responses, can't have positive effects as well. The research finds that those kinds of things can also have positive effects, but the positive effects of taking responsibility for having caused harm tend to be greater and much more consistently seen. So a couple of additional things I want to say about responsibility taking. The first is that many victims also would like to have acceptance of responsibility for other people who enabled wrongful conduct. Okay? They would like people who enabled the conditions for wrongful conduct to happen to take responsibility for their part in supporting those conditions or failing to prevent wrongdoing or failing to stop the harmful behavior. Second, responsibility taking could but often does not, even when someone is willing to take responsibility, it often does not extend beyond the original harassing behavior to admit responsibility for subsequent denial, deception, or retaliation. Right? Those two things tend not to be included in in responses. And those, we've seen already discussions of those secondary bad acts resulting in significant additional harm, additional barriers to people feeling comfortable reporting, right? And are part of what victims wish to hold offenders accountable for. And that's one of the things that Megan Gantz found notable about Dan Harmon's apology, was that he not only articulated what he had done in the first instance, but also the ways that he had responded to her after she had objected to his behavior. Third thing I want to say about responsibility taking is that many survivors would ideally like to hear responsibility taking from their perpetrator, right? But accountability and responsibility can be also accomplished through other avenues such as the courts, right? So when they can't get responsibility taken from a perpetrator, having a court or a jury define where accountability lies is also something that they welcome. Okay. So in addition to having a voice, being acknowledged, having someone take responsibility, victims also care about ways to repair the harm, right? Sexual misconduct does harm, right? There are physical and mental health consequences, right? There are lost professional opportunities, lost professional assignments, career advancement problems, career interruption problems, right? And repairing those sorts of harms is important. Now, some of the things I've already talked about can contribute to harm repair. So having a voice, being acknowledged, having there be responsibility taking can help repair some of the harms of sexual harassment. But an additional way to repair harm, of course, is through financial compensation. Right? Survivors deserve to be made whole under the law, and some of the discussion that we've had this morning is about some of the problems with the law that gets in the way of that kind of redress. Okay? There's also a deterrence function to compensation, right? Making sexual misconduct expensive for alleged abusers may have a deterrence function. Okay? And damages are one way to repair, in particular, concrete financial harms, lost professional opportunities, lost income, expenses related to physical and mental health care, and so on. But money damages are also symbolic, right? They can serve to accomplish some of victims' other goals, right? Serve symbolic purposes. Damages can serve to provide a form of acknowledgement, right? They can serve as evidence of accountability, right? They may serve to help reaffirm a victim's self-worth. Okay. Money damages are not the only form of repair that is appropriate. Things like community service or efforts to effect reform might also be a way of repairing harm that has been done. I'm going to circle back to that in a minute. Okay. One thing to note is that you may have survivors who are hesitant to seek individual compensation. Right? For some survivors, that will be very important to them, and they will want to seek that and are clear about that. Other survivors may be hesitant. Right? Some of them may feel like money damages is not commensurate with the kinds of harms that they have experienced. Right? And those preferences ought to be respected. Right? So thinking about the autonomy of victims to control how their claims are handled and what their goals are is important. At the same time, I think attorneys and the community needs to be aware of the kinds of social pressures there can be on survivors to be hesitant to seek financial damages, right? So concerns about how they will be viewed by others and critiqued by others as ambulance chasers or gold diggers, and you see that in the public cases that we've seen of people making claims in the context of sexual harassment. Or finding that their credibility may turn on whether or not they seek financial compensation, right? So they're more credible if they are not seeking financial damages, right? That's a potential problem, and I think it's one that we need to think about and grapple with. Survivors of sexual misconduct are often motivated to speak up and say "me too" or take some other kind of action against offenders in the hope that they can prevent additional harm from occurring. The Me Too movement has relied, at least in its early phases, on naming and shaming, right, as a tool aimed at preventing recurrences, right? But many of the statements we have seen from, at least the ones that get reported publicly, perpetrators tend not to offer specifics about how their behavior will change in the future, right? And institutions don't always have good specifics about the changes that they will make in order to prevent these kinds of harms. And the discussion we had earlier this morning about social responsibility, I think, are the early steps in that direction, to think about how do we, as individuals and as institutions, do what we need to do to prevent recurrences of harmful behavior. Okay? Many survivors are concerned that offenders will be quick to apologize but slow to change. Right? And that is something I think we need to take seriously. Right? With respect to prevention, right, survivors may be concerned about prevention of the behavior of specific individuals. Right? But they also are interested, many of them, in influencing institutional behavior and affecting systemic change. And this desire for reform means that it's important to think about the institutions, about the structures, about the norms, about the practices that contribute to the problem of sexual misconduct as part of an appropriate response to individual claims and to the movement as a whole. Okay? And it's important to think about, when we're thinking about institutional responses, that in terms of harm repair, right, simply restoring an inequitable status quo is not really repairing the harm. Right? It's important to think about how and what we are going to do to transform cultures and institutions that underlie the bad behavior that happens. Okay? It's also come up in some conversations about Me Too, and particularly in conversations about institutional change and what should happen in the aftermath of Me Too or the aftermath of particular claims, about how we reintegrate survivors and perpetrators back into a meaningful community. Right? And what does that look like? So for survivors, that means things like listening to their stories, addressing the employment setbacks that they have experienced, the other aspects of repair that I have been talking about. Right? For many survivors, reintegration of the offender is secondary, but also important. Right? So, and it's something that is only beginning to be discussed about what do we need to do to reintegrate survivors, and what do we need to do or should we do to reintegrate perpetrators. Right? For offenders, what is required as a precursor to reintegration, and what that reintegration looks like, depends and should depend in part on the nature of the offense. Right? Its severity, its intentionality, its pervasiveness, right? So we ought not have a one-size-fits-all set of requirements for perpetrators, because there are lots of different sets of behavior that we're talking about. But whatever we're going to define that work to be, that work needs to be done. Okay? The notion of earned redemption comes from the restorative justice literature, and it anticipates that offenders will be held accountable for their behavior, and that they will be enabled to earn their way back into the trust of the community. Right? Those two things need to happen together, right? Not just one, not just the other. Okay, so I've got this quote from Ashley Judge. She says, there's an appropriate sequence, right? Accountability, introspection, restitution, and then redemption. You don't get to skip the stages that lead to redemption. Right? Now, I don't want to be heard to be saying that offenders have to become moral saints, right? But they should make restitution to their victims, engage in service to the relevant community, confront the harm caused by their behavior, and learn from their experience and help others to do so as well. Okay? Now, one thing that comes up in this context, and thinking about reintegration, thinking about sort of comebacks, right? Thinking about what should happen in the aftermath of some of these claims, is what about forgiveness? right? If reintegration is possible, what does that mean for forgiveness? There's a huge psychological literature about forgiveness, that it can benefit both victims and perpetrators, psychologically, physiologically, emotionally, right? But it's important to think about what forgiveness is and what forgiveness is not. We need to have a nuanced understanding of what that is. Forgiveness as a psychological construct is about the forgiver. It is not about the offender, right? And it involves an intrapersonal process. It's about the letting go of resentment. It is not about an interaction with the offender, okay? So importantly, neither forgiveness nor reintegration should mean that offenders are not to be held accountable, right? Or that they are exempt from punishment or reparations, right? Forgiveness and accountability can coexist, right? And making amends should be a precursor to reintegration or forgiveness, but they do not dictate that there must be forgiveness, okay? Similarly, forgiveness does not mean that a survivor must reconcile with a perpetrator, right? That is up to the individual survivor. And despite the common refrain that we hear that says forgive and forget, right? Forgiveness does not necessarily imply forgetting, right? It's important to remember what has happened so that offenders can learn, society can learn, and others can protect themselves as necessary, okay? The other thing that's important to think about in the context of forgiveness is that we need to be aware of the pressures that are put on survivors to forgive perpetrators, right? Particularly when perpetrators have responded in an appropriate or semi-appropriate way, right? Research has found evidence for sort of a script that prescribes how an apologetic interaction is going to go, right? And it starts with an injury, right? Then there's an apology, and then there's forgiveness, right? And that is sort of the pattern that is expected, right? What that can mean is a victim who chooses not to, or is not able to, or doesn't want to do it at this time, forgive, can feel the pressure of that expectation, that the appropriate response is to forgive, right? And that they will then be sort of turned into the wrongdoer because now they are holding a grudge, right? And part of what is important in thinking about the goals for individual victims is to think about whether forgiveness is part of that victim's set of goals, right? And whether that victim finds that useful or not. Not that there should be an expectation that they must forgive or reconcile or interact with the perpetrator, okay? So in thinking about this whole range of goals and responses and remedies, it's important to realize that community responses to wrongdoing and what communities require from an offender, whether that's the legal system, whether that's an employer, whether that's us as observers, right, and support systems, those responses communicate something about the collective's view of the violation. Right, they communicate something about the underlying social norms. They communicate something about the value of the survivor. So it's important for us to think broadly and collectively about what messages we want to send. Meaningful consequences and meaningful repair for victims can serve to condemn the treatment of the victim, confirm the value of the victim in the community, and reaffirm, or in this case is probably more appropriate to say recreate, a shared set of social norms and values and expectations for behavior. So I'm happy to entertain your questions.
Does anyone have questions?
So I think we'll go ahead and take a second to say thank you, of course.
Good.
And now we're going to get our panel all set for you guys. Give us like 2 to 3 minutes to get them set, and then we'll get going.
My name is Rachel Lugay, and I'm the managing editor of the Public Interest Law Review. And today I have the honor of welcoming Professor Kevin Woodson. Prior to becoming a professor at the University of Richmond School of Law, Kevin Woodson was an associate professor at the Thomas R. Klein School of Law at Drexel University in Philadelphia. His scholarship focused on employment discrimination, racial diversity in higher education and the professions, and education reform. His works have appeared in Fordham Law Review, Cardozo Law Review, and Georgia Law Review, amongst other venues. He is currently working on a book entitled Beyond Bias, The Significance of Race for the New Black Elite. Professor Woodson was previously an associate at Wilmer Cutler Pickering Hall and Dorr in Washington, D.C. He earned his PhD in Sociology and Social Policy from Princeton University, his JD from Yale Law School, and his BA from Columbia University. Please join me in welcoming the moderator of our panel on sexual harassment in the workplace, Professor Kevin Woodson.
Thank you very much. And so we have a great panel here today, and they have a lot more to say than I do about these very important topics, so I am not going to waste too much of your time with the lengthy intro. But I would like to say that it's great to have this panel today in light of the recent developments. We have attorneys who have extensive experience addressing issues of sexual harassment and misconduct in a number of capacities and professional roles, both representing employers and representing employees, and also advocating more broadly with respect to these issues. And they're here, they're well situated to offer us compelling insights into the realities of sexual harassment law, and also to discuss what impact, if any, the Me Too movement has had in this realm. And so I'd like to introduce our wonderful panelists. We have Janice Kraft, who's an attorney with the Virginia Sexual and Domestic Violence Action Alliance. The Action Alliance is a direct services, advocacy, and membership organization that aims to create a Virginia free from sexual and domestic violence. Prior to her work with the Action Alliance, Janice served as a policy director for NARAL's Pro-Choice Virginia and clerk for the Chief Judge of the Court of Appeals of Virginia. Janice is a graduate of William & Mary Law School, where she served as editor-in-chief of the Journal of Women and the Law. Prior to attending law school, Janice worked as a victim advocate for the state's attorney's office in Volusia County, Florida. And so we also have Katie Dean, who is an associate at the firm of Locke & Quinn. Since joining Locke & Quinn in 2015, Ms. Dean has worked extensively on family formation, personal injury, and employment matters in both federal and state court. Ms. Dean graduated cum laude from the University of Richmond School of Law in 2013, where she was a John Marshall Scholar, a member of the McNeil Law Society, and was awarded the Oral Brown Award for Clinical Excellence in the Children's Law Center. Patty Gill is an attorney at Patty Gill PLC in Glen Allen, Virginia. Ms. Gill and her firm provide labor and employment law services for employers of all sizes, locations, and industries. Patty has exclusively represented employers and management for more than 19 years. Prior to starting her own firm in 2012, to focus on the counseling and compliance side of her practice, Patty was an employment attorney at Hunton & Williams, LLP, for 9 years. And Rebecca Royals is a founding member of Butler Royals in Richmond, Virginia. She focuses her practice on employment law, civil rights, and complex civil litigation. Although she primarily represents employees, she has also represented employers ranging from local small business owners to national corporations. Ms. Royals has been listed as a Virginia Super Lawyers Rising Star from 2009 through 2013 and was selected by her peers for inclusion in the Best Lawyers in America in 2013 in the practice area of litigation, labor, and employment. And so, since first going viral 1 year ago this week, the Me Too movement has brought unprecedented national attention to the prevalence, pervasiveness, and unfortunately the permanence of sexual harassment in the workplace and beyond. And its impact on women and other workers across the country has been a frequent topic of conversation in social media and in real-world settings. In the years since the accusations against Harvey Weinstein gave rise to this iteration of the Me Too movement, sexual harassment has received more sustained attention in our national dialogue than ever before. Hashtag MeToo has been used by millions of social media users and has detailed thousands of incidents involving sexual harassment and other forms of misconduct. Therefore, it would be easy to refer to this panel as timely, but unfortunately, this is going to be a perennially timely topic, as the history of Me Too itself demonstrates. So Me Too, of course, was first coined more than a decade ago, way back in the MySpace era of social media, by an activist who was dealing with other issues of sexual violence. And so, unfortunately, this is just as timely now as it was then and likely will be in the future. Of course, Me Too has for the most part involved women coming forward with their experiences publicly, but without necessarily pursuing any formal legal or administrative claims to address their situation. And during this panel, we are going to focus on those formal and administrative processes by which attorneys might enable their clients to get relief. And we're also going to look at the impact of Me Too on this domain, and we're going to think about ways in which some of the rules, policies, practices, and tactics that attorneys, employers, lawmakers, and others pursue can be used to make progress here. So I've rambled on long enough. I know we're here to hear the insights from our panelists. So I wanted to open up with a very broad question for everyone. And the question is, as attorneys and advocates who are professionally engaged in this space, how do you feel about the Me Too movement? What are your thoughts? Has the increased publicity had any impact on the actual conditions that women and others face in the workplace with respect to these issues? So I can call on someone?
Would you like us to go down the line? Sure, I'll go first. And speaking, I'm the attorney who represents employers, and so I help counsel employers. A company will come to me when, let's say, they get an internal complaint of sexual harassment, and I'll help them with properly dealing with that internally. My advice has not changed. My advice in terms of how my clients should handle a complaint by a female employee or a male employee about harassment hasn't changed. They need to do all of the things that I've been saying for years, which are immediately separate the alleged, the complaining employee from the alleged harasser. Interview her in a compassionate and respectful way, get all of the facts about the inappropriate conduct, and then thoroughly investigate them, and then circle back with her and communicate with her or him. When I say her, I mean it both genders, but definitely the most of my claims are by women. And then circle back, stay in touch with her, implement corrective action against the alleged offender if there is, if that's warranted. What I've seen change the most, I would say, in the last year is that ties, he said, she said situations, you might hear that, are breaking in favor of the complaining employee and not as much in favor of the alleged accuser. And what I mean by that is there's a lot of times where alleged sexual harassment has happened behind closed doors or just walking out to the parking lot. It's typically a man and a woman. And there's no witnesses, and there might not be text messages, there might not be emails. So there's no corroboration. In years past, companies have kind of stuck to the criminal standard, which is not applicable in the workplace, of course, but we all know it, innocent until proven guilty. And prosecutors don't bring cases against someone unless there's, a huge burden met beyond a reasonable doubt, right? So historically, companies have, when there's a tie and there's not evidence to kind of break the tie and prove the bad conduct occurred, they side with they don't terminate. They might write a letter to the male employee's file or something like that, but they've been very reticent to terminate and take that ultimate employment action. So now what I'm seeing and what I'm advising, because you're weighing risks, right? The risk of not taking action when there's a tie and not giving the complaining employee the benefit of the doubt is so great. It's greater than getting a wrongful termination claim, say, from the male employee who was accused and claims he's innocent. That's the biggest change I've seen, is the ties are breaking in favor of the complaining employee.
And I represent plaintiff's side 99% of the time. The other 1% of the time I'm pretending to be Patty, but I think she probably does a better job with that. Probably the primary difference I'm seeing in my practice to date is a greater willingness to report and a greater willingness to follow through with action. So I tend to get a lot of people coming in on a consultating basis wanting to say, well, I've got this situation, what are my rights, what can I do? And my answer is always going to be the same, okay, we need to report. If this is a supervisor that's the problem, is there a reporting procedure internally? Is this something we need to immediately address externally? What's the severity of the situation? What is at stake here? There are practical considerations as well as legal. And a lot of times I have people who say, okay, that's good to know, I don't think I want to do anything, because the practical implications are often so great. At this point, I feel like we have a number of women and men, but to a lesser extent, I think, who are much more emboldened by the fact that there are others out there. It is in the common discourse now. It is in the media. And while we're seeing backlash, I think writ large, at the more local level and more organically, we are still getting that initial shockwave kind of coursing through, at least what I'm seeing, in the workplace. So, as Patty said, I think employers are being more responsive now. I'm going to argue sometimes it's Band-Aid treatment and a lot of window dressing. I'm not sure that anything is always changing. Some employers, I'm sure, are taking real efforts and real steps, and other times, all right, well, let's have an HR seminar about not grabbing your coworkers. Good guys. But people do now feel a little more willing. They're less alone. They know it's being discussed. They know, at least with some employers, being treated a little more seriously. So they're more willing to take either an initial reporting step, or sometimes it's more comfortable and more practical, and they just need to go ahead and go straight to the EEOC, avail themselves of legal remedies. There are many steps along the way, but people certainly are coming forward and taking those additional steps, I would say, in greater percentages than they previously were.
Yeah, absolutely. And just to echo a little bit what both Patty and Rebecca said, I think a big effect that the Me Too movement has had for plaintiffs, which is who my firm mostly represents. Occasionally we will represent employers, but usually we're on the employee side of things. Really just lessening the evidentiary burden in these cases, which can be really, really massive. I think, as Patty touched on, a lot of times these are he said, she said situations, and now that more people are feeling more comfortable coming forward, you can turn them a little more into he said, they said, which is really eases that burden on plaintiffs when they're going through what can be sometimes a process of almost re-traumatizing them, just going through the legal process of making a complaint and pursuing any kind of legal remedy. What I would also like to see happen and hope that this movement would lead to would be employers thinking twice about using the she's crazy or she wanted it defense, because those are defenses that we unfortunately prepare our clients for when they come in, and say, this is what happened, I would like to do something about it. As plaintiffs' attorneys, we really have to set client expectations and say, here's what you have to be prepared to go through if you're really gonna, take this case to a litigation stage, is that, if the defense is denying that this happened, you're gonna have people calling you a liar. The defense is, a lot of time is going to be, you're making this up, or, oh no, you invited this conduct, which can be really, really difficult for victims who have already been brave enough to come forward and speak out and be truthful about it, to have to go through that. So I would like to see, hopefully, the Me Too movement have that effect, but I think already what we're seeing, just in terms of people being more comfortable coming forward, is plaintiffs feeling less isolated when they're the ones coming forward to make a complaint. They might have some support and some corroboration, and so this is not giant uphill battle from an evidentiary standpoint.
Maybe. Well, we'll see. In addition to just, echoing all the remarks of the other panelists, I would say that, certainly an immediate impact that we saw at our organization was this, recognition that kind of the old ways of addressing sexual harassment in the workplace are not really working. Like a one and done training that somebody takes on a computer when they first start working with an organization is not an effective way to address prevention of sexual harassment in the workplace. It's not an effective way to address sexual harassment in the workplace, period. We were almost immediately engaged by an attorney who primarily does defense work on behalf of employers, and she proactively reached out to my organization to say, what can we be doing here? What can we do to address sexual harassment in a far more holistic way? And so I think there's been a recognition coming out of the Me Too movement. This is a chronic issue that requires sort of chronic treatment. Again, it's not a one and done problem. And another thing that I would say, in addition to just that consciousness raising and women and men and gender nonconforming folks and others recognizing that they're not alone in this if they've experienced sexual harassment in the workplace. But there's been kind of a trickle down too, where again, we, when Me Too first exploded, well, not first, but for the second time exploded onto the scene a couple years ago, this was a movement that was primarily led by, wealthy white women in the entertainment industry. But I think we're seeing as an outgrowth of that, a recognition and an understanding, that women, particularly women of color and women engaged in low wage work, women in the service industry, agriculture, restaurant industry, we're seeing that this is really such a prevalent problem in those industries as well. So we're seeing, I think, an expanded recognition of the myriad ways and in myriad sectors that sexual harassment and violence affect employees and workers.
So thank you. All of you have hit upon issues and questions that I hope to raise. So I'm having a hard time figuring out what to go back to and when. But I wanted to ask, I guess, about that last point that you mentioned, Janice, the disconnect between the media coverage of Me Too is focusing on, almost exclusively it seems, on instances where powerful, wealthy, influential white men are abusing their power to exploit white women. And I wanted to ask, how, if at all, does that affect your work in terms of the consciousness raising or the advocacy that you do in this area?
I think that in our work as advocates and attorneys, we just have to be very mindful of, sort of basically intersectionality, and multiple and intersecting forms of oppression and discrimination that occur, in the workplace as well as in, society as a whole. It's one thing for a, white collar professional, sort of economically advantaged white woman to experience sexual harassment. That's not to diminish her experience, but that's one type of experience. It's a far different experience for example, a woman of color who is engaged in low-wage work, living paycheck to paycheck, perhaps, a single parent supporting children on one income, perhaps non-citizen, perhaps not an English speaker, or at least doesn't speak English as her primary language. So again, I think that we just have to be, mindful in our work that there is no sort of one-size-fits-all approach to addressing sexual harassment in the workplace, again, depending on the individual experiencing that harassment and what his or her workplace happens to be. Just as we wouldn't, approach an intimate partner violence situation as a one-size-fits-all approach, and just as we wouldn't, counsel a person in every situation. Oh, well, we have to be sensitive in an intimate partner violence situation. There may be myriad reasons why a person might not leave or can't leave that situation. It's very similar in the employment field. There may be myriad reasons that a person is more or less forced to remain in an unsafe working environment, and we have to figure out ways that that person can sort of safely navigate that situation. And again, we have to be mindful that there's not a one-size-fits-all approach to that.
And for those of you who practice in this area, representing clients in actual disputes and litigation, how do these differences affect how you go about representing clients? Are there any, general patterns or pointers that you could share with us?
I'm trying to think of the best way to answer that question. I think there is a discrepancy, and this is maybe going in a slightly different direction from what Janice had talked about, but between the sort of Hollywood representation of this movement and how great it's been and the effects that it's having, and the clients who come to my office and sit down and have a complaint or maybe want to bring a case. And while I think we all just talked in response to your last question about all the positive effects that we're seeing the Me Too movement have, I think that there's also an element of reality check for a lot of the clients who come into our office who have felt empowered by this movement and come in and say, all right, I've seen all of those ladies on Fox News got $1 million settlements, so it's time to hold my employer accountable, and really just explaining that's very nice. We're still in the Fourth Circuit. The Title VII still has the standards that it has. So let's set some expectations about what this is going to be like. So I do think there's a discrepancy between sort of the movement as portrayed on TV versus the reality of clients who actually might be litigating these issues. So, which is slightly different, I think, from what you talked about, but
very important.
Yeah, and I'd add, I'm kind of piggybacking on what Janice said, and this thing is kind of difficult to deal with. It's really about meeting the client where they are. And so your client's options, as you said, are not always going to be ideal, and they're not going to be able to have the result or even the welcome, warm reception that Gwyneth Paltrow has, or whoever comes out and says something. And a lot of times you've got someone who has no, either didn't speak up because they had no concept of what their rights were, and so sometimes that can be very liberating when you get somebody who's been in a position and they just finally say, I need to do something, and they find out what their rights are. It can also be really crushing when you take that a couple of steps down the line and they realize what that is ultimately probably going to mean. And I say that, meaning that in a lot of these circumstances, and I'm sure Patty has seen something that's different from that, but in a lot of circumstances, at least when you get to the litigation or pre-litigation level, you're talking about a separation where somebody's not going to be employed anymore, and some people can't afford to roll those dice to start with. So it's very much case by case.
And would you like to add anything to that?
No, go ahead.
So I want to follow up on the last point. The Me Too movement has largely centered around claims of incidents that in many instances occurred years and years ago. And I know that presents special challenges in the legal context. Statute of limitations, of course, but even other different evidentiary difficulties. And so I wondered if any of you could talk about how you manage those types of situations and how you go about advocating in that context.
Yeah, that's a really tricky one, is when you have someone who has not felt empowered to speak up previously, and then now they do, and they come to your office and they're telling the truth about what happened to them for the first time, and as the attorney you have to say, I'm so sorry that happened to you, you are outside the statute of limitations, you don't have a legal remedy at this point, because our statutes of limitations haven't really changed. We've got, if they have a tort claim, they've got 2 years in Virginia. If it's Title VII, they've got that 300 days to file the EEOC charge, and then you wait for 6 months while the EEOC investigates. And then you have to really quickly file your claim, and then you're looking at getting on a federal court docket if you even are getting that far. So we still have these same pretty quick statutes of limitations, which are preventing claims from women who were victimized earlier and just didn't feel comfortable coming forward. We do have a couple of odd exceptions for people who were abused as children in Virginia. Not odd, I mean good exceptions. I didn't mean to characterize them negatively by saying odd exceptions. But I just think exceptions that maybe not everyone knows about. Of course, if you're the victim of a tort when you're under 18 in Virginia, generally your clock doesn't start running until you turn 18. But if you're the victim of sexual abuse, you actually have, and I don't want to misquote the statute, so I wrote it down. But we have a statute that says every action for injury to a person, whatever the theory of recovery, resulting from sexual abuse, so this would be an abuse situation, not just a harassment situation, necessarily occurring during the infancy or incapacity of the person, shall be brought within 20 years after the cause of action accrues. And then we also have another exception, which is much longer, and I'm not going to bore you by reading the whole statute, but it discusses cases where the fact of the injury and its causal connection to the sexual abuse is first communicated by a licensed physician or psychologist. So this is maybe people who have repressed memories. So we do have a couple of extensions on our statutes of limitations in Virginia in somewhat unique cases. That being said, if someone is trying to bring a cause of action 19 years after it happened, your source of recovery at that point that you're looking at may be greatly diminished or completely gone. Your evidence of what happened after 19 years, it's likely going to be very hard to recover. So even with extended statutes of limitations, I think you're running into very big problems with people who unfortunately didn't feel able to come forward earlier.
Well, I mean, from my perspective, what I look at, and of course I'm torn, but as a practitioner for employers, it would be very difficult to investigate a comment case. And what I mean by that is a claim of sexual harassment that didn't involve a touching. I just distinguish those in my mind in that when it's a tort and when we're referring to it's a tort, it just means, you can also sue for assault, for battery, intentional infliction. You do have other avenues of bringing claims that do have a little bit of a longer statute of limitations than that short 300 days. But the comment cases, I mean, my clients won't be able to do anything to stop it if someone doesn't come forward and tell them in real time so that they can, before the individual either resigns or gets terminated or whatever the case may be. So, I mean, from a practitioner for employers, I favor the quicker statute of limitations for the comment, again, just comment cases where someone is making comments that doesn't result in any physical touching, there's no nudity, there's no Harvey Weinstein. Those are obviously very different.
And so, do any of you who represent employees disagree? Is having a tight statute of limitations on balance necessary for the orderly resolution of these matters?
I mean, I think that in one sense, yes. I mean, for me to do my job, for Patty to do her job, we have to have some line in the sand. Otherwise, memory becomes faulty, evidence is gone, and it becomes, I think, more traumatic to pursue for someone past a certain point in a lot of cases. However, the fact that there are exceptions, and I think there could be more exceptions than what we presently have available to us. I think we need to have loopholes for all sorts of cases where things have occurred. I mean, we've seen on display the difficulty recently with Supreme Court nomination hearings and whatnot about when something has happened so long ago and you have conflicting testimony and often a dearth of witnesses, intentionally or not. So, statutes of limitations have a function. I'd like to see them be a little bit longer than they are, 2 years or less in the case of the Title VII EEOC administrative exhaustion requirement. Really, I think are not doing some of the victims any favors, particularly, again, because here we are with Me Too, and some people are just now feeling like they can come out And it's the most crushing thing in the world, where somebody has something that happened that would have been specifically under Title VII, and it happened a year ago, and unfortunately we didn't make it to the EEOC within that 300-day timeline because they just now came out and said something. You know, it's tough.
Yeah, these are obviously tremendously complicated and complex issues.
I also wanted to just make a note on the comment cases. Those I completely understand. I mean, I think for plaintiff and defense attorneys, being able to investigate it in a timely manner is important, and we always encourage our clients, even if they're not moving forward with an EEOC charge at that time, making sure things get reported to the company in a timely manner, if only to build a record. But Title VII also has this severe and pervasive standard that you have to meet, and so in comment cases, usually one comment is not going to do it, but you're still on this 300-day timeline, so you kind of have to wait until you meet the standard, make sure it's part of an ongoing violation so all of them count, and it can be a tricky line to walk sometimes, I think, when you have a short 300-day window in which you've got to catch that last violation, so it's still within the statute, but you also sort of have to have enough bad conduct that you're meeting the Title VII standard, so it is a little bit tricky, and I don't know that it's a perfect system the way it is right now.
And I'll throw in one more thing, if I may, and this is a little bit farther afield, but it's not that we can always help the person who comes in as a prospective client, because statute may have run, where you have something like an ongoing hostile workplace situation, and perhaps this individual who might have otherwise had a claim has been removed from that situation, but is still familiar with that workplace, is acquainted with other individuals who may be subjected to that. I mean, at that point, sometimes they become a silent standard bearer. They learn, okay, these were my rights, I'm out of time, but they end up going and galvanizing others who are still there, and that is one way of affecting change. That's certainly a little more dispersed, but that is something that we do see happening, I think, a little more, especially once again because people have been encouraged that others are coming forward, and so they say, gosh, I really wanted to do something about this, but I know Sandra in accounting is still having to work for this guy, and I think I'm just gonna reach out and see how she's doing, and gets the ball rolling that way.
And so I believe Rebecca and Katie both mentioned that it seems like more employees are coming forward and interested in pursuing their claims. But as the Me Too movement has made clear, the vast majority of people who are victimized by this type of employment misconduct do not come forward. And I assume that hasn't changed overnight. Obviously, the data is still a little dated now, but what can be done, if anything, to help those workers? For those of you who practice here as advocates or as in the litigation context, why aren't more people coming forward even now? And what can be done about this? I don't know, Janice, if you have anything to add.
Sure, I can start us off. It's kind of a tough question because I think that if we're talking about, what can we do to sort of improve conditions so that people feel, more empowered to report instances of sexual harassment? We're almost, missing the forest for the trees, because it strikes me that we're going to have a pretty difficult time creating conditions where people feel empowered to report if we're not kind of, widening our lens and saying, what are the conditions that we can create in the workplace where we're preventing this kind of behavior from occurring in the first place? So again, I think that we really have to focus both on prevention in the workplace, and I think we have to, address the fact that, we deal with sexual harassment in the workplace and experience sexual harassment in the workplace just as an extension of our culture as a whole, which, quite frankly, unfortunately right now, rewards some pretty toxic behaviors. We talk about things like rape culture, but we talk about, again, society as a whole, unfortunately, still teaches, right, men and boys that they're entitled to women's attention, that they're entitled to sex, that they're entitled to all sorts of things. And so I think that we have to sort of examine our culture writ large and as a whole in thinking about why we still have why sexual harassment in the workplace is so commonplace and why people are afraid of reporting.
On the prevention in the workplace front, I think that it's so important for companies. I know we talk about training, and you said it's much more than just showing a module on a computer, right, and having everyone sit at their desk for 45 minutes and click through. I really favor respect and civility training and really embedding that into my clients' cultures in many other ways than having people sit for 45 minutes and listen. I've done sexual harassment training for a client before, and I had the employee come up to me after and say, gosh, you did such a good job. That was so entertaining and interesting. It's too bad the company is just doing this to cover their butt. We all know why they're doing it. And so if employees feel like it's simply checking a box, it's me too, oh, we have that required sexual harassment training, and that's all you talk about, I think employees don't really feel like it's an open environment and it's a culture shift. I think, in addition to making it more broad and it's about respect and civility of everyone, being inclusive with everyone, age, race, sex, all of the protected classes, I wish that more of my clients would either film the CEO doing an introductory part on video, or if it's a small company, have my business owner get up and tell everyone, this is important and I want you all to listen, and this is part of our culture, and I agree with this training, and I signed the the respect in the workplace policy, and I want everyone to take this very seriously. I think the tone from the top has to be so strong and supportive of it, because employees do it because they think they can get away with it. I mean, simply put, it's human behavior. It's like my 9-year-old son. If he knows I'm not looking, he just might do it. And if he knows if there's no repercussions, it might do it again. I think it's the same, just core kind of fundamental human behavior. Now, the Harvey Weinstein, again, that's a level that I'm not even talking about. That's just a different level of completely awful behavior that I'm talking more about the kind of routine comments again. But I think it has to come from the top. If the CEOs would get up, if the executive team would get up and say, I did this training, I signed off on the policy, I support this, and I want everyone in this company to listen and comply with this, I think it would be more accepted by the employees. And then another key part, again, you do the training, you set the tone, you work it into your core values and your mission statement at your company, and have it in different publications, not once a year for 45 minutes again. I think it's really important to handle the investigations right, to look the complaining employee in the eye and listen compassionately and take notes and show respect to him or her. The way HR or outside investigators handle it is so important, because employees go back and talk and they tell their friends and they tell their spouse, oh my gosh, I feel so much better for coming forward. Whereas when a botched investigation, when I see that come across my desk and I read the notes and no one circled back with her, that's definitely going to land in litigation. And man, if you're in California, I've had plaintiffs' lawyers tell me, you can't possibly settle this for less than $800,000. It's Me Too movement. When are you guys coming to the table? I mean, it's expressly being thrown in employers' faces, at least in California. Rebecca wouldn't talk like that. But it's, the investigation and the compassion and the respect for the complaining employee is so important. And then, of course, taking the appropriate action. And the employee sees that. When someone is terminated, employees see that. They know it. It gets embedded in the culture that there's not a tolerance for it. Kind of just 4 parts that I think are important to prevention.
And I would echo that. I mean, looking at it from the other side and looking at what an employer does, a couple of things. Number one, the question, why don't victims report? Once again, we've kind of seen nationally recently why that might be. And feeling like there's an employer who's not going to respond appropriately, not seeing a termination of the problem employee, seeing questionable responses there. And I have seen in many cases where you talk about where there is a compassionate response, where there is respect, I do get cases in that I don't take because they don't rise to a level. There may be something happening in the workplace that shouldn't be. That doesn't necessarily mean that it's going to actually constitute a violation of the law. And so then we're at that middle ground area, that sort of gray area. Should it be gray? No, but it is. It's our society. We sometimes have bad actors who may not be intentionally bad actors. And while we want to educate and eradicate that, ultimately, at the same time, you do have these sort of one-offs with employees who ought to know better but aren't really trying to be harmful. And so I get people in and they say, well, you know, my boss made this remark. And, you know, it's like it's the one comment thing. That's not going to get us anywhere under our standard. But a lot of times, if they complain internally about something that may, once again, not be a claim for them, but is a real area of concern in workplace culture, if they complain and are not responded to, I can tell you their attitude. Now, I'm not going to take their case, but somebody will, you know. So they'll find somebody that tries to make something out of this. Whereas if they are dealt with respectfully and with appropriate compassion and concern, and the employer follows up, even if it's just a, you know, counseling session, like, look, Jake, you can't tell that joke. And maybe that takes care of the problem. Now, if it doesn't, we're talking about a whole new level. But just that respectful response in the most sort of de minimis cases is huge and could go a long way in changing the culture overall, I think, and encouraging victims to report.
Absolutely. I mean, I think the reason people don't report in workplace situations is because they still have to work there. They have to get up and go to work the next morning, and if it's going to be just as uncomfortable for them after having reported, you know, the bad behavior of a colleague that they still maybe have to see and interact with unsupportive, you know, bosses, then, you know, what are they getting out of it? So I think exactly what Patty and Rebecca said about just making sure that the workplace environment is one where they can come forward and not be risking putting themselves in a worse position when they have to get up and go to work the next day is going to encourage more people to come forward and be honest about things.
Thank you. And I wanted to follow up on that a bit to, I guess, dig even deeper. There are best practices, as I'm sure you're all aware, that tend to look awfully similar in this context and in other employment contexts. So training is often referred to as being a critical component of that. Top-down buy-in is a buzzword that gets thrown about. And I wanted to get a sense of whether you all, in your professional experiences, have actually seen the impact of maybe a workplace that took these issues seriously and made positive changes, or if it's just too difficult to measure.
I can, being the primarily representing attorneys, employers. I have a great example. It's a law firm client of mine, and a male partner brought forward a complaint to the office manager and the managing partner that a female paralegal was being subjected to some comments by a senior partner. So one thing I've seen is that male employees are complaining more than I've ever seen before. I think that Harvey Weinstein has reduced everyone's tolerance for this kind of behavior, men and women. Of course, women collectively have had intolerance to it. It's what I see is that men don't like it either, and they're speaking up about it. Maybe they didn't like it before, but they're vocalizing it. And this male partner brought a complaint forward, and said she's fearful. He's obviously a senior partner. His name is in the firm. She doesn't know what to do, but I want it investigated. I want it to be investigated and dealt with appropriately. And I was engaged. I was asked for my advice. They followed it to a T. Everyone involved, the managing partner, the office manager that I was working with on the investigation, they wanted to do the right thing. They wanted her to feel comfortable. They, despite the fact that this was a founding member of the organization, and action was taken, and I feel really good about the way they handled it. It was last December, so it was after Weinstein broke, and it was in the forefront of their minds. And some of the conduct had happened outside of the office at a wedding. They weren't sure if that they could even look into that, and asked, can we consider that? Is that part of the workplace? Is a wedding, part of the workplace where he did something objectionable? Absolutely. It's your employee, and that's your named partner, and you have an obligation to treat that and look into that as well. So, and they did, and things are going great now. I think that she's very comfortable. There's been no claim, and that was an example for me of one of my clients really handling it, taking it seriously, having a good faith effort all around, and then having a good result as well.
And are there concerns about employers motivated by the threat of litigation to take steps that, I know one panelist referred to this as window dressing. Are there concerns that actually this publicity will enable employers to, I guess, obscure the impact of some of these issues by seeming to do all the right things without following through or monitoring them? Is that a concern among any, especially for those of you who represent plaintiffs in these matters?
I would say that's not a particular concern because if something's happened, it's happened. I mean, my concern is that, yeah, they're again going to be putting the Band-Aid on the bullet wound, right? What I want to see is real, lasting, impactful change as opposed to the window dressing we were talking about. But at the same time, if we're just dealing with window dressing by the time it gets on my desk, that's pretty obvious, and we're going to do what we need to do with it. So I don't know, for purposes of someone who's already got a claim, that makes any real difference. But yeah, it sure would be nice to think that this is all the real deal and we're seeing some actual affecting change here.
Yeah. I mean, my clients are terminating offenders, so I know that's a very significant action. It's the ultimate punishment in my world, and they're doing it, and they're doing it in ties. Again, the he said, she said situations. More and more of my clients are erring on the side of terminating and assuming that the employee is telling the truth and not needing that, absolute proof, the email or the text to terminate. So I think that they're doing it. They're taking action. If that's window dressing, I mean, people are losing their jobs, so it's pretty serious.
And I had one last question, and then I wanted to open up the floor for audience questions if there are any. I know we started a bit early, so I'm not sure exactly how we're doing on time. Are we? Okay, perfect. So I know that the Me Too movement has produced a number of policy reforms. We see this in the federal and state context. There have been efforts to ban non-disclosure agreements, especially. And this is something that's had mixed success so far, but there have been laws passed in at least some states. And I wanted to get a sense of whether you all thought this was going to be an important positive step toward dismantling the structures that enable this type of behavior in the workplace, or might there be unintended consequences that outweigh the good here?
As a plaintiff's attorney, I get the thought process, I think, and the potential value of not having non-disclosure agreements in terms of, you are able to have this corroboration and the support. That being said, my duty when I have a plaintiff is to my individual plaintiff, and non-disclosure agreements are a huge bargaining tool and a huge piece of leverage to get my client the biggest recovery possible. I like having them as an option. So
for leveraging during negotiations?
Well, and a lot of times, I also want to say, the plaintiff wants it confidential as well. This is something she wants to put behind her. If the case is able to be settled and everyone can agree, all right, this is not going to be public knowledge, this is going to be confidential. She doesn't want, if she's going on to another job, she doesn't want to worry about it. It might be something that's following her. And again, there are cases where I have seen the harm. I also had a client come to me and say, I know that there have been other complaints brought and they settled all of them and none of those people will talk to me, but I know it happened. And so she was in a tougher position because she didn't have the corroboration that she was like, I know that the employer knew that this guy was a problem, but none of the people that complained before are gonna come forward and support me because they're all, they settled their cases and they signed their non-disclosure agreements, and that was really tough for her. So I see the harmful side of it. That being said, the thought of just outlawing non-disclosure agreements, to me, it takes a potential tool out of my tool belt as a plaintiff's attorney when I'm fighting for an individual plaintiff, I think.
Yeah, I would see a lot fewer of my clients be willing to settle any kind of complaint, and they'd be forced to just fight it to a jury trial. I believe that that would be detrimental on both sides. No plaintiff wants to go through 1.5 to 2 years of being dragged through the mud and their credibility tested and challenged, and then to have to go sit through a jury trial. On the other hand, my clients, the companies, they don't want to spend 2 years worrying about it and paying lawyers to fight these cases. But I think that if employers can't get confidentiality when they pay a settlement, I just think that they were going to be forced to say, okay, our back's against the wall. We're gonna have to fight it now. We're gonna have to come out and just aggressively fight this thing. And then if a jury tells us we were wrong, then the public will get that. But our communication has to be, no, this didn't happen. We're gonna fight. I think the settlements would go down, and we'd have a lot more trials. Which again, I don't think that helps either side. I always advise my clients to resolve cases, unless it's something that they really know that it's an untruthful claim brought in bad faith, or there might be some other really, extraordinary reason to go to a jury trial. I don't think it helps anyone. I wouldn't want to take a sexual harassment case to a jury right now, I'll tell you that, and I haven't, so I don't know who is. They are in California, and it's not going well.
Any dissenting views, or is that pretty much that's interesting. I thought that this would be a topic on which we'd be more divided, but it seems like a difficult issue. So I wanted to open up for the floor to audience questions.
Got a mic for you. Thank you. I have a question. And I apologize if this is veering a little bit outside of the employment context, but I think it's become increasingly relevant. So I think that the Me Too movement has certainly emboldened victims to come forward. I also think that recent events in particular have also emboldened perpetrators. And we are definitely dealing with many victims who, and we've discussed all the reasons that victims wait, and sometimes don't bring timely cases, but we're working with a lot of victims who would like to come forward, but who are being threatened or actually sued with defamation. And so it becomes a sort of a challenge where survivors of sexual violence or sexual harassment have enough barriers in coming forward. And I'm wondering what the interplay with that kind of liability is. Let's say that they lose or can't prove their case. How do you advise clients on how to mitigate their risk of other liability for simply bringing the issue forward? And specifically, there was a hypothetical mentioned where somebody has actually left the employment and is advising current employees, like, well, here's how to deal with this known perpetrator, right? And there's still harassment going on. The person during the lunchtime panel suggested, and anecdotally, I think this is true, most victims are motivated by trying to prevent future harm. So they may not be going just straight down the line of file a claim with the employer, then go to the EOC, then sue. They may not be taking that linear path. They may be doing something sideways like that, which I think does expose them to liability. So I don't know if you all have any comments about that, but I think it's an increasingly frequent threat that perpetrators are using.
I mean, I would say sort of the old saw about truth being the ultimate defense to a defamation claim. So there's some of that there. And I think if somebody's in that position and motivated, I mean, yeah, you could always, have a slap suit situation. But I'm not seeing much of that. And of course, an actual filing would be protected. So I think it's a real concern, especially as we're seeing so much polarization around this issue and so much backlash that I think is going to increase before it gets better. But it's not something I'm encountering a whole lot. And I think, if somebody is on good footing and acting in good faith, I guess if we're advising someone, there are ways to advise around actually exposing yourself to something like a defamation claim.
But again, I think like what Rebecca said, the context of where they're making the statements is critical. If they're going to the press and speaking openly and disparagingly about an alleged offender, that's going to be actionable. If it's in the course of the lawsuit, it's going to be protected by that immunity. So where they're making the statements, they just need to be counseled on, if you make the statements in this venue, if you go down in the grocery store and yell to everyone that this person did this, or if you go to the press or some unprotected venue, that's where those claims are going to get more traction.
Are there any other questions?
You talked about how a lot of the ties, assuming that the complainer is a woman, that the ties are going to the woman now. And so it seems like there's some backlash to that. And you hear things about men now not wanting to be, or trying to protect themselves from, if they think something is perceived, so they won't be in a room with a woman alone, or they won't go out to dinner alone with a woman. I think even the vice president said something how he won't have meals with women. And so I'm curious what your thoughts are in terms of women. It's setting women back in a way in terms of maybe losing out on opportunities and companies, if that makes sense.
No, it does make sense, and that is a little bit of a natural consequence. I think men are walking on eggshells a little bit more than they used to be. I just think it'll swing back around eventually. I think that's an initial reaction. I haven't heard a lot of that. Maybe you guys have, or I think that it's better for everyone to be mindful about it and be a little too careful than to be a little too loose. That's my opinion.
From like an attorney and an advocate standpoint, I mean, I don't think that we're asking a lot of men, particularly just, men, people in power generally. I don't think we're asking a lot of people in power generally to just engage in a little bit of self-reflection and maybe a little bit of self-discipline with respect to how we interact both with our peers and with our subordinates.
And advice I've heard is that if you use common sense and you refrain from being a jerk, you will usually be okay. But I haven't read any empirical studies on this, so I think we had another question.
I'd be interested to know how much kind of non-monetary aspects of these settlements. So we've heard a lot about apologies and about maybe corrective action, which is where we always have this interesting, is private litigation really a mechanism to do that? And I'd be interested to know if that's actually on the table in these cases.
So from an individual perspective, there are a lot of non-monetary options that can be built in that have to do with, anything from just negotiating about non-disclosure, confidentiality, things like that, all the way to where someone's going to land next, and recommendations and referrals and things like that at the individual level, obviously. As far as a broader, more hopefully culturally shifting movement, I've had things where we've had employers agree to have basically report to the EEOC on some issues. They've agreed to conduct trainings. They've agreed to deal with things on a larger basis. This is not the norm, by the way. In my world, employers tend to be reluctant to make sweeping changes when they can just, if they don't feel that they need to in the first place, and if they can just sort of deal with this one thing. So it's more rare, and I would say the more plaintiffs I have with a particular claim in one instance. So if I've got multi-plaintiff litigation happening, I'm much more likely to have an actual larger response. But it does happen. And you mentioned apologies. That's probably the thing I can get the least. I can probably get EEOC reporting and stuff like that more easily than I can get an apology. Nobody wants to admit liability. And that would probably go the longest way, just, for anyone out there representing employers. If you want to get this for a better deal, why don't you apologize to my client? You'd be amazed at how far that would go.
So do we have any other questions? We have one in the front. Sorry to make you...
This question is actually for Patty. So in my world, as a prosecutor, we're still dealing with stereotypes and assumptions that women should handle certain types of cases and not cases. Rebecca, Katie, and Janice are sort of the stereotype in these types of cases of who are going to be the plaintiff's attorneys. They're the women representing the women. Do you get any backlash as considered the woman who is now representing the employer against the woman from other women? And then on the flip side, do you get backlash from the employers, especially maybe earlier in your career, because your advice is incredibly reasonable and it is sound, but it's not, she's crazy, we can fight them to the end and take her out. Did you ever get any backlash of, well, you're just saying that because you identify with the plaintiff as a woman?
I never got that.
Awesome.
Early in my career or now, I never got that. I just haven't gotten that. I haven't gotten that. I've had some clients who didn't want to do the right thing. And, I feel like that's the minority. I feel like my advice on these topics maybe is more respected by my clients because of my gender. I don't know. But I haven't gotten backlash from women for the work that I do. My friends who aren't lawyers, they love what I do, because what I do is I help companies comply with laws, and I help companies handle these complaints correctly. I would not be able to sleep at night if I had to go to trial on she's crazy, unless I had a letter from a doctor 15 pages long telling me that she actually doesn't know what she's saying and she made it all up. I would not be able to do my job if I was putting women down. Now, have I taken a deposition of a female sexual harassment claimant where I had to get aggressive with her about her criminal background or complaints she'd made against other companies? I have. Did I feel a little uneasy about that? I did. I was doing my job and aggressively taking a deposition, but I also feel like I was defending a claim that my client was saying was not true and was not legitimate, and we did have reasons to doubt her credibility. So I haven't gotten backlash on either of those scenarios. And again, like when I tell my kids, what I do for a living, my mom helps companies treat their workers right. I mean, that's what I do. I advise them and I tell them to do the right thing, and hopefully 100% they do. Maybe 99 out of 100, I can deal with that too.
And I actually have a thought on that, just to piggyback on it, which is that I think, and I think it is a result of a cultural bias where we still don't, our default is not to believe the victim. Our default is to apply innocent until proven guilty to a non-criminal claim. But I think having Patty on the other side, if I'm in front of a jury, Patty on the other side is a way of lending a certain credibility to the employer's position. See, a female attorney thinks that this is okay. Likewise, if a male plaintiff's attorney representing a female, it lends a certain credibility, again, in the eyes of the jury, perhaps, that, oh, well, no, really, I'm a guy and I believe her. I think that's a little bit unfortunate, but I think that gender shift or sort of the juxtaposition is probably helpful in both of those situations.
So I think we're out of time now.
Yes.
I'm being cut off by the authorities.
If we can take a second and just give our wonderful panelists. And that actually also concludes our program. So just one more round of applause for our speakers who are still here. And thank you all for coming today. Travel safe on your way home.